Hey everybody, if you are coming in, we are listening to oral arguments today about compassionate release. I am waiting for them to start. We actually have this case, which deals with compassionate release, and then it'll be compassionate release under the First Step Act next. So we're waiting on those to start right now. Let's see. They're loading, so give it a second. These are going to start soon. This first one is whether a combination of extraordinary and compelling reasons that may warrant a discretionary sentence reduction under 18 U.S.C. 3582 can include reasons that may also be alleged as grounds for a vacatur of sentence under 28 U.S.C. 2255. Sorry, I'm just waiting for these to start. Why is this not wanting to do what I want it to do? Hold on. Let me time that out. But yes, we are listening to a bunch of oral arguments dealing with compassionate release this morning. So these should be interesting. We've had an uptick in compassionate release since 2010-ish or so, and we'll be dealing with when can they do this. It should be starting soon, it looks like. Give it just a few minutes. If you have any questions, you're welcome to put them in the comments, but we are waiting for them to start, and it looks like the feed is not recycling, so it should be any minute now. I usually start about 5 minutes late. Let's see. In this one, a district court has broad discretion to reduce the term of imprisonment in any case that it finds extraordinary and compelling reasons warrant a sentence reduction. The sole limitation Congress placed on that discretion is found in 18 U.S.C. 994T, which provides that rehabilitation of the defendant alone shall not be considered an extraordinary and compelling reason. In reversing the district court's grant of compassionate release to Joe Fernandez, the Second Circuit held that it was an abuse of discretion for the court to have considered evidence bearing on Fernandez's potential innocence, as well as to have found a disparity in sentences between Fernandez and several of his co-defendants who were cooperating witnesses. I believe this is dealing with specifically an armed robbery case. I could be wrong. I'll look that up in just a second, but I believe that's what this case was about. Fernandez and several of his co-defendants who were cooperating witnesses, that decision was contrary to the decisions of the First and Ninth Circuits, which have held that district courts are not restricted with respect to matters that they may consider under 18 U.S.C. 3582 other than set forth by Congress. The question presented is whether the Second Circuit erred in recognizing extra textual limitations on what information a court may consider when determining whether there exists extraordinary and compelling reasons warranting a sentencing reduction. I believe, if I'm correct, this was an armed robbery situation. Evidence came out. I believe something about what I want to say was one of his co-defendants, like their credibility and things like that. So that is my recollection of this. But again, I can relook this up as we're going through it. Let's see. Let me reload. I don't have anything yet, but next few minutes my show's on. I'm glad you like it. It should be starting soon. This is Supreme Court drama reel. Every case we're going to be hearing today has to deal with compassionate release. This one is first. The second one is compassionate release in accordance with the First Step Act under two cases where there was some extra grounds that they are considering now. I hate it when they start like a couple of minutes late because I start thinking something's wrong with my feet. Come on. Let's see. If y'all can just tap the screen if you're in here, I appreciate you so much. It helps the live. I appreciate all of you. Luckily,
we will hear argument first this morning in case 24556, Fernandez versus United States. Mr. Groenstein.
Mr. Chief Justice, and may it please the court. When Congress established the extraordinary and compelling reason standard for sentence reductions under Section 3582, it chose words that set a high bar for when courts may grant such motions. It also chose words that do not prescribe what types of reasons will qualify. Instead, it delegated that task to the Sentencing Commission and required that district courts comply with the Commission's guidance when exercising their discretion under the statute. This case presents the question whether Congress has implicitly prohibited district courts and the Sentencing Commission from considering any reasons that may also be alleged as grounds for habeas relief. It has not. Under the plain meaning of the statute, if a court finds an error that significantly increased the length of the defendant's sentence, that fact can contribute to a finding of extraordinary and compelling reasons to reduce the sentence. And even when a court finds no error, it may nonetheless decide that the circumstances surrounding the defendant's sentence were so unusual and unfair as to be extraordinary and compelling. That's what happened here. The government's position is extreme. It contends that no argument related to a defendant's judgment may even be considered in the extraordinary and compelling calculus. It posits that only personal circumstances like age and illness are relevant. Our position is modest. We recognize that personal circumstances are common reasons that courts find to be extraordinary and compelling. But we reject the government's view that courts can never consider an error or unfairness in a defendant's sentence in that analysis.
Side note, these are the only little
allowing courts to grant a sentence reduction in rare cases based in part on circumstances that could have been addressed on habeas will not frustrate the habeas statute's procedural limitations. There is no basis to adopt the government's non-literal reading of 3582. I welcome the court's questions.
Do you think the term compassionate release suggests the circumstances that you have in this case?
Your Honor, the term compassionate release is a term that has been used colloquially and was used at one point in a Department of Justice regulation. We certainly concede that that term does seem to relate to personal circumstances, but it doesn't necessarily foreclose the possibility that courts would consider other issues related to the fairness of the defendant's sentence.
So during the years that the Bureau of Prisons actually initiated this process, were there any circumstances in which a trial error would be the basis of the motion?
Certainly, there were very few cases, period, when the BOP was involved.
But were, even in the few cases, were there any of this nature?
There were not, Your Honor.
What was the nature of those?
Those were generally where a prisoner was terminally ill or old. And
in other words, personal circumstances.
They were certainly...
I think largely here the biggest contention is that in the Fernandez case, they're kind of using it as a backdoor around an actual appeal of the case. Like when you appeal your case, you don't get a whole new case. You do not get a whole new case. You have to present actual evidence. And when there's not like something that substantiates this appeal, they're saying like you're using this as a way around that. So that's something to keep in mind.
Part of the circumstance is a change in law.
Sotomayor.
Banks, U.S. versus Banks, 428 F sub 1088, 1977. And in that case, the court considered rehabilitation, which is now prohibited by the new policy statement as being a sole ground, correct?
That's correct. In the case that Your Honor referred to
But nevertheless, back then, Bob relied on rehabilitation, correct?
rehabilitation, absolutely, yeah.
And the Diaco case, I think you're minimizing
Shouldn't
it.
that be the goal, though, is rehabbing people?
Was a New Jersey case.
We have the
where
highest
Bob
recidivism
made
rate
a motion to the court
and
for
incarcerated
compassionate
citizens
release,
per
and one of the
capita.
factors was a change of sentencing, correct?
Absolutely, Your Honor.
Of
So the two
First
published
world
opinions
country.
were both BOP and weren't limited to just personal circumstances.
That's certainly correct. Absolutely.
Counsel, you say the situations in which these would arise will be rare and unusual. Why in the world would that be the case? You've got somebody sitting in jail and they got 20 more years to look at, and you go in and say, gosh, I think there's like a 1% chance, you might be able to get out.
Cedar,
The prisoner's going to
Alito,
say,
or Gorsh,
oh, okay,
I
it's only
can't ever
1%.
tell.
Let's forget about it. Every lawyer would bring these claims. And some judges are going to grant
They all
them,
sound
and
the
some
same.
are not going to grant them.
The guys anyway,
and
except for Thomas.
I'm not sure this
And Kavanaugh.
factor is not something that Congress took into account. And it does seem
Sorry,
that this
I'm not
is...
trying to talk with
Well,
my mouth full.
why would this remain rare?
Certainly, Your Honor. And the reason it would be rare is precisely because of the habeas statute, that the defendant did have an opportunity potentially to raise these issues on habeas. Maybe he procedurally defaulted. He will then have to show why he procedurally defaulted. What were the circumstances surrounding that? Because merely procedurally defaulting on a potentially meritorious claim normally would not be found to be compelling.
Did the meaning of extraordinary and compelling reasons change in 2018 when Congress enacted the First Step Act?
That's not our position. Our position is that it is meant
So
the
when
same
you
thing,
hear something
and that would
has
the
to be
dictionary
like
definitions of
extraordinary and compelling,
since 1984.
it means it has to be both. You
until
don't just get
1980,
extraordinary
until
or
2018,
compelling.
only the director
You have to have both
of the
there.
Bureau of
That's
Prisons
something to keep in mind.
could invoke the statute, right?
It could be compelling,
Your Honor.
but not
Is
extraordinary.
it plausible that Congress intended for the director of the Bureau of Prisons to make motions for sentencing reduction based on an assessment of the strength of the evidence or any factor
think
that
this
has
is
to
Gorsh.
do with the trial proceedings or the sentence that was imposed?
I could be wrong.
I do believe so, that it was at least possible, Your Honor, as referring back to the cases that Justice Sotomayor discussed.
Yeah, they're two isolated cases, but doesn't that seem to be far outside of the area of the director of the Bureau of Prisons' expertise
Well, there could be
and
issues.
responsibility?
Thank you guys.
That's certainly true, Your Honor, but
If
I
y'all
would
can just tap the
suggest that
screen,
the
I
other
would appreciate
agency
it so
that is
much.
involved
It
in
helps a lot.
3582 is the Sentencing Commission, and there was a delegation to the Sentencing Commission, whose expertise, of course, goes far beyond the Bureau of Prisons to set up guidelines. The Congress did not delegate that task to the BOP.
And why would our consideration be limited necessarily
Jackson.
to what was in the purview of the BOP? I understand that there was an amendment that allowed the statute or allowed these motions to be brought by a defendant and essentially bypassed the BOP. So I'm wondering
Yes.
if that doesn't indicate Congress's intent to allow for the consideration of factors that the BOP either wasn't able to or wasn't considering.
Well, certainly,
Yes.
Justice Jackson, we do agree that when Congress amended the statute, the reason it did so, and it was quite explicit about this, was to allow more circumstances to be raised. It's our position, it's not because the BOP was not able by law to do so, but that the BOP was not bringing enough of these
And they
sorts of
weren't.
motions.
Like by the
Counsel, you can't
numbers,
have it
they
both
weren't.
ways. Either extraordinary and compelling reasons remained the same after the enactment of the First Step Act, which is what I understood you to tell me, or it changed in 2018, which is what you seem to have suggested in response to Justice Jackson. So which is it?
No, I'm not saying that the meaning of the words changed. I'm saying that what Congress intended in the First Step Act was to allow these sorts of motions to be made more broadly.
And in any event, I thought your argument was that Congress never gave content to extraordinary and compelling circumstances in the first instance.
That's
that
absolutely.
It, in fact, ceded that authority to the Sentencing Commission.
Absolutely. And Congress used words that were intentionally broad to allow the Sentencing Commission to give guidance on circumstances that it might not have anticipated when it passed the first.
But the Sentencing Commission has not authorized this kind of activity, has it?
At this point, certainly for our case, the Sentencing Commission hadn't spoken. The current policy that was passed
Has spoken or
has not, for purposes of our case.
Right, and in your opening, you therefore said the question is whether they've implicitly prohibited. Isn't the question rather whether they've authorized this kind of motion?
Yes, in our view, by using words that are as open-ended as extraordinary and compelling, and then by explicitly delegating to the Sentencing Commission the authority to give guidance, that is the authorization. Congress did two things here. One, it used very broad language, and second, it gave an explicit delegation to the Sentencing Commission.
Right, but the commission, I'm sorry.
No, finish.
But the commission hasn't in turn said that this kind of legal error is a basis for this kind of motion, correct?
At this point, the Commission has not spoken to that. The Commission
shouldn't that be, or how relevant should that be in how we think about this? In other words, the Commission could, it's subject to legal challenge, but it could identify this kind of circumstance as the basis for such a motion, but it has not done so, even though it has been authorized, as you say, by Congress to elaborate on what the authorization means.
Yes, Your Honor. From 2018 until 2023, the Commission had provided no guidance that applied to defendant-initiated motions. So at that point, courts were simply acting under the meaning of the statute. So yes, we certainly expect and we would hope that the Commission could provide further guidance on this issue, but it has not yet taken that opportunity.
Counsel, can I ask you a question about whether you have to go to 2255 first or whether you can go straight to the compassionate release statute? You answered when the chief was asking you questions. In that interchange, you suggested that the prisoner would have to go to 2255 first because otherwise it wouldn't be a compelling circumstance for release. So are you reading kind of an exhaustion requirement into compelling so that someone in your client's position would have to try to get relief through 2255 first before invoking this other procedure, or no?
No, Your Honor, that's not our position. Our position is that as part of the extraordinary and compelling analysis, courts would consider whether a defendant sat on his rights or whether he's taken all opportunities to enforce his rights. Even if a defendant did not go through 2255, he would still have the option to argue under 3582 that his situation is extraordinary and compelling, but his position would be weakened by the fact that he did not take the opportunity to enforce his rights.
Why would you ever bother with 2255? It seems like it would be a lot easier to just go the other route, as long as you have some other circumstances to invoke.
Well, for the first reason would be that 3582 sets a very high bar for defendants. It has to be extraordinary and compelling. Also, the relief that a defendant can obtain under 3582 is limited. He can only reduce the sentence, whereas the relief under 2255 is much broader. He can attack his conviction. Also, there will be plenty of errors where a court will not feel comfortable simply releasing somebody, but rather would want to correct the error by
vacating a sentence versus releasing somebody under compassionate release are vastly different
things. It's true,
things.
Congress changed it because those sentences were extreme, right? They were extremely long. And it seems to me that if indeed that's extraordinary and compelling, the disparity between similarly situated defendants who get the benefit of the act and who don't, I mean, why wouldn't that be extraordinary and compelling on its own terms? And plus, there are downsides too to attacking the validity of your conviction, because then you could be subject to retrial.
That's right, Your Honor. And it certainly can be extraordinary and compelling, but to date, courts have interpreted the phrase narrowly. There have only been, by our count, 12 cases since 2018 when the first step was enacted, where a court, based on an argument that could have been raised on 2255, in part granted a sentence reduction. So courts have been using this very infrequently to grant relief.
But 2255 has some harsh limitations. You know, there's a short statute of limitations. There is preclusion of second and successive petitions for the most part. You know, can't you imagine that defendants who face those limitations, and you know they filed their 2255 motion 3 days late or something like that, that this would then be used essentially as an end run around those prohibitions?
Your Honor, I don't think it would be an end run.
That's what I was talking about at the beginning. Are they trying to use this to subvert
even if you do claim
an
an error,
appeal
will not
or vacation
necessarily
of the sentence?
be granted. It will be difficult for that. And I agree with Your Honor that there are harsh limitations associated with 2255.
Yes.
And Congress has stated that those limitations are appropriate, but it doesn't mean that in every case, as applied to every defendant, that those limitations are fair. And under certain circumstances, if a defendant misses a limitation by 3 days, he may not be able to challenge his conviction.
I want to point that out. We don't like that, but it's also true.
Argue this unfairness, the error and the unfairness of him not having been able to bring it under 2255.
I suppose what I'm suggesting is that, you know, Congress, for better or for worse, made a determination that those are the limitations that it wanted. And even to the extent that a judge thinks that they're unfair in all cases, in most cases, that I doubt that Congress meant for individual judges to override its own judgment.
Absolutely, Your Honor. And that's certainly a limitation that should be placed on 3582, that a judge cannot simply second guess a decision made by Congress. But even where Congress creates a generally applicable law, such as a mandatory minimum, it doesn't mean that Congress even believed that in every case that would be fair to the defendant. And all we're asking for is that a judge can consider that the way the law has been applied to this defendant has been unfair or even potentially erroneous.
And I thought in response as well to Justice Kagan's point, is the thought that the limitations that exist in the habeas context are relative to the actual aim of habeas and goal of habeas, which is vacatur of the sentence. It's also not discretionary, where the defendant has satisfied the criteria of demonstrating that his sentence is unlawful. The court has to, according to the statute, give him habeas. And so, yes, there are strict limitations, but there's also this particular goal. It seems to me that compassionate release is a totally different thing. And so, to the extent that compassionate release is about the court's consideration of a sentence reduction, one might think that the same limitations aren't intended to apply, that it's not actually an end run in any meaningful sense. These are just two different regimes, and it doesn't seem to necessarily follow that the considerations in one are mutually exclusive, such that they can't arise in the other.
That's absolutely correct, Justice Jackson, and it's worth remembering that Section 3582 is as much an act of Congress as Section 2255 and should be given respect.
Is there anything in the statute or the legislative history to suggest that Congress wanted the 3582 sentence reduction dynamic to be limited in some way by what could have been raised in habeas or what is happening in the habeas scheme?
That's a good question.
Is there anything that links those two in the text or even in the legislative history?
Thank you guys.
Absolutely not, Your Honor.
It helps so much.
In fact,
I appreciate all of you.
The court has given guidance about how when there is a potential tension between two statutes, how that tension should be resolved, and that's the Prizer line of cases. And it's not simply that one statute can be seen in some circumstances to evade the other. What happened in Prizer in that line of cases was that 1983 was seen as a potential end run around every single constitutional 2255 motion. And that's why the court found that a literal reading of 1983 would swamp the habeas statute. It would wholly frustrate Congress's goals. Here, allowing defendants to bring motions under 3582 C1A in the rare circumstances that they could get relief, having a sentence reduction under those circumstances would certainly not frustrate the procedural limitations under habeas. And for reasons I said earlier, courts should actually take into account those procedural
And in
limitations.
fact, it would enable the kind of quote unquote safety valve that Congress expressly in its reports, et cetera, in describing compassionate release, that's, I think, the design of it.
That's absolutely correct, Your Honor, and that's precisely how the two statutes sit one next to the other and not in conflict. Habeas applies generally to claims of error relating to a conviction or sentence. 3582 is the safety valve that can be applied to reduce a sentence should all of the other avenues of relief fail.
The question is safety valve for what? I mean, not every safety valve is a safety valve for everything. And I would not have thought that it's a safety valve in order to relitigate trial errors in the way that a 2255 motion is. That's the entire point of a 2255 motion. So, you know, I guess I don't see any evidence that Congress meant for this to be a kind of do-over statute.
Well, Your Honor, perhaps the best evidence of it is the words that Congress used. They said extraordinary and compelling. Those are words that don't have a specific meaning, and it's given to the court to decide what is an extraordinary and compelling circumstance. So there are cases, we cited the Trenkler case, where someone had been sitting in jail for years. He was sentenced to a life sentence, even though the statute under which he was convicted, which had been amended just slightly after his verdict, and that's why no one picked up on it, said that he could not be convicted, not be sentenced to life. So in that situation, if he could have raised it under 2255, he should have. And maybe that detracts slightly from a finding of extraordinary and compelling. But when he's sitting in jail serving a life sentence, that is unlawful. That's all we're saying is that that's something that courts should be able to consider as one of the factors, just as much as age and illness.
Well, suppose that a defendant,
it's the law at the
prisoner,
time, not the
claims
change.
that there was a fatal error at trial, but doesn't bring a 22 after the direct appeal does not bring a 2255 for 3 years, therefore misses the statute of limitations. What would be extraordinary about that situation and would allow the prisoner then to try to get a lot of the relief that could have been obtained, maybe all of the relief that could have been obtained under 2255 by filing a 3582 motion?
Well, Your Honor, certainly there can be some things that are extraordinary and compelling about those circumstances. One, we would have to understand what is the prejudice that fatal error had on the verdict. Did it change it from an acquittal to a guilty verdict? Then why did the defendant, if this was such a glaring error, why did the defendant not
and when we generally
bring
think
a
of extraordinary and compelling,
Maybe
what we're
he had a
thinking
mental
of is
breakdown
like
and couldn't
somebody
speak to his lawyers
has
during that time. We don't know the
stage 4
circumstances.
lung cancer.
All we're saying is that
somebody
all of
had
the
something
circumstances
extreme happen in
should
the
be
family.
considered as part of the extraordinary and compelling analysis.
And even the
same way that
family
personal
stuff is.
I understand that. To go back to your answer to the Chief Justice's question, suppose you're advising a whole string of prisoners who have been convicted, they've lost on direct appeal, and for one reason or another, they all have claims of trial error or some other flaw in their conviction, but they're all barred from proceeding under 2255 because of the statute of limitations or some other factor. And you look at their claims and you think this is not a ridiculous claim. Would there be any circumstances in which you would not file a motion for sentence reduction?
Well, Your Honor, I think the same could be asked of anyone who has any medical illness or is approaching older age. Is there any reason they wouldn't? And this is precisely what the Sentencing Commission is authorized to do, is to put in guardrails. But to Your Honor's question, I think the close calls of when there's, potential error, I'm not sure that that's the sort of unfairness that courts would typically find extraordinary.
Well, I'm not even talking exclusively about close calls. I'm talking about arguments that are not so frivolous as to damage your professional reputation if you brought them.
Well,
wouldn't you always do that?
Absolutely, Your Honor. And
So if this isn't going to be unusual,
I think what
it's going to be standard.
I think what would be unusual is that courts would find the compelling circumstances that we're talking about. The First Circuit I cited in our reply brief, after Trenkler in 2022, there has not been a single case that we found where a court has granted a compassionate release motion in a situation where an argument that could have been raised on habeas was the basis for that motion. So we haven't seen that level of motions being filed, but we certainly anticipated.
So we're really getting down to it. What
that
these
the Sentencing
justices
Commission
seem
could
to
put
be
the guardrails.
circling
The same way
wagons
that
on.
Congress, that the
Is
Sentencing
this a
Commission-
workaround?
Keep going, sorry.
I'm
Or
just going to say
are
the same way the
these
Sentencing Commission dealt
conditionally
with the flood of
extraordinary and
these
compelling?
compassionate release
Is this
motions
what
during
Congress
COVID.
intended to do with this?
But the Sentencing Commission, like Congress, has not authorized or envisioned or articulated anything close to this kind of legal error being the basis for this kind of relief. And that concerns me because, as Justice Kagan said, you don't see anything suggesting that Congress wanted a do-over kind of
And I
statute, but you
keep
don't see
seeing
anything
people
from the
hitting
commission
that you want
either.
to
Your case
contact
would
me,
be
just
obviously
DM
quite a
me
bit stronger if you had the
because
commission having identified this as they have with
I
some other
don't know
things.
how to look
Certainly,
at those.
Your Honor, but I
I'm
think that what we
TikTok
should
kinda
read into the
dumb.
Commission's silence on this
I can start
is that
a lie.
these will be
That's about as far
cases
as
that
I
will
go.
be few and far between where a court would actually find the circumstances.
Well, how do
to be
we know
true.
that? I mean, first of all, as Justice Alito says, I think they'll be far more common that they're brought, so that'll be a whole new docket, one imagines, of these kinds of motions. But how do we know that individual district judges are going to, as your word, be modest or routinely deny these?
Well, Your Honor, certainly we haven't seen in the circuits that have allowed it. We haven't.
But
seen
if you win this case, one imagines that could, supercharge the efforts to use this.
That's
in
correct.
fact, you would want that, wouldn't you? Don't you want this to be used more often?
Well, I'm just representing my current client, but
your legal position
This
would.
is a
our
good
legal
question.
position is
Your
that
legal-
this should be something that should be in the mix.
Thank
And
you,
certainly
Bonzo.
courts will take into account several things that I think would limit their exercise of discretion. First, they would take into the fact that there's the law of the case. If an issue had been raised, courts should not be revisiting it.
If it
Second, I
conditionally
think it's
doesn't
likely
meet
that these
extraordinary
sorts of
and
arguments will be
compelling,
made
can courts work
mostly
around and
in
use
cases
this
of
to
mandatory
just
minimum sentences,
anything?
where the element of
These are the
unfairness
questions
that
we have to
arises
ask
from
when
the
it
error
comes to this.
could not have been considered before. So we're seeing how the universe of cases where this sort of argument would be made is getting smaller and smaller, and rehabilitation is certainly an
Thank you,
area where
everybody
you would
coming
expect
in.
many motions to
appreciate
be brought
all
in. There
of
have
you.
been,
If
but
you can
still the
tap the
number
screen,
of
it helps so
total
much.
compassionate release motions is modest, and if the commission speaks more, will be even more modest.
Thank you, Counsel. Justice Thomas? Justice Alito?
Well, you just mentioned mandatory minimum sentences. There are a lot of district judges and other federal judges who don't like mandatory minimums. So if a prisoner has been sentenced to a mandatory minimum sentence, could a district judge say, if a motion under 3582 is made, you know what, that mandatory minimum is too much under the circumstances of this case, so I'm going to grant a sentence reduction?
Well, Your Honor, Section 3582 does allow sentencing under 3582, under the mandatory minimum for any extraordinary and compelling reason. But certainly it's our position that a court could not just say, I don't like mandatory minimums, and therefore I won't apply them. It has to be something about the unfairness of that mandatory minimum in a particular case.
Would you agree that one of the principal goals or a major goal of the Sentencing Reform Act was finality? The Sentencing Reform Act got rid of parole. It didn't like the situation where someone would be sentenced to 30 years in prison. This was standard at the time. Maximum a life sentence was considered to be 30 years, but then after 10 years, the person would be paroled. It got rid of all that. Would you agree that that was a major goal of a major objective of the Sentencing Reform Act?
Absolutely, Your Honor, but it was also a goal in 3582 to have a safety valve where judges could still exercise discretion at a
He
later
keeps
point.
talking about the safety valve, but he
Mrs.
hasn't
Sotomayor?
particularly pointed to
Counsel,
it.
I'm assuming here that a basic part of your argument is that actual innocence claims are not cognizable under 2255 at all.
That's based on our understanding of what the court has said to date.
We've never said they are.
That's correct, Your Honor.
And so whether 2255 would be implicated in some other claim is irrelevant to your claim. This is an issue that couldn't even be raised there, not because of a procedural bar
This
or
is
anything else.
Sotomayor.
It's just not cognizable.
That's correct, Your Honor, and that's one of the difficulties in this case, is that
All
if
right,
the
now,
court's...
may I go back to a problem I have with your case, which is all of the facts that Judge Hellerstein relied upon were known to him at trial. He knew what your client's claim of innocence was. He knew all the evidentiary weaknesses that he wrote about in his current opinion. He knew that only one shot came from your client's gun, et cetera, et cetera. The only thing he did not know was the exact reduced sentence that the co-conspirators would receive because they were sentenced after your client. But he knew they were going to get a substantial reduction because they were cooperators. How do we call that new and compelling evidence? Compelling or extraordinary evidence?
So
It's
the
all-
judge was aware
there's nothing
of
new.
all the new issues they're
I would
bringing
have
up.
an easier time
Now
if
they're
I
saying
thought
this now constitutes a compassionate
actual
release.
innocence had been proven after the fact.
Yes, Your Honor, there was another fact that Judge Hellerstein did take into account that he had not focused on previously, which is that the getaway driver was sentenced to 2 years in prison. And that suggested to him that the government itself had concerns about the credibility and the reliability of the cooperator's testimony.
All right, now you
That's
said
interesting.
earlier, and I agree with you, both age and medical condition or any other reason doesn't ever stand alone. Because there are old people who are not released from prison. There are sick
She's
people
right.
who are not released from prison. It's one among many circumstances. Your claim of, and I put it in quotes, actual innocence, doesn't stand alone. But what does it stand with in this case? There certainly was no medical
Extraordinary
need.
and
There's
compelling.
no age need.
Both.
There's no extraordinary circumstance to this individual. So why isn't it only one factor?
What it stands with, Your Honor, is the fact that despite the
Thank you,
judge's
everybody.
concern about
Again, I
innocence,
appreciate all of
that this
you. If you
defendant
can
was
tap
sentenced
and
to a
like
life
and
in
do all the
That
things.
is what bothers me.
But Your Honor, is
That it's a judge's disquiet as opposed to an individual circumstance. Because no matter how you look at extraordinary and compelling, it focuses on the individual, not on the judge's disquiet. By the way, I was a district court judge,
She's not
and
wrong.
I have a great deal of respect for the disquiet that sometimes judges feel. It happens to every district court judge. There's a case where you really struggle. But can we, in the facts of this case, denote that that is an extraordinary circumstance?
well, what I would say, Your Honor, is that this is the sort of discretion that judges generally have in sentencing, and it's reviewed on appeal for abuse of discretion. The
But-
Court of Appeals didn't review it for abuse of discretion.
Well, I agree with you, and maybe that's what they should have done.
Oh.
But I
Oh.
am troubled by this.
Mrs. Kagan?
I mean, just to continue in that vein, do you think that the district court here on the initial trial could have received the jury's verdict of guilt and said, you know, I'm not going to overturn that verdict of guilt. I have no basis for doing that. But in the sentencing, I'm going to reduce the sentence because I feel disquiet with respect
judicial
to that
discretion
verdict.
on the
Could the district
sentencing.
court have done that?
Well, certainly not in this case, Your Honor, because it was a mandatory life sentence. But as a general matter, while the court does have to take the verdict as given when conducting the guidelines analysis and the 3553 analysis, how the court weighs the different factors, such as personal circumstances, the nature.
This is why I don't
and
support
the characteristics and
mandatory
history of the
sentencing.
defendant. It can certainly weigh
Because
those
it can
factors.
Well,
differently.
personal you
Be
brought
a
into
sort of
doubt. I
unilateral
really was limiting
solution
it to
to
would it be
things that
appropriate
actually do
for a
require
district court to
discretion
say,
among
not
judges.
overturning the jury verdict, but I'm not sure I agree with it. Therefore, I'm going to reduce the sentence below what I would ordinarily give.
I think in weighing the 3553 factors, as long as the court recognizes that the verdict was guilty and takes that into consideration, how it weighs the verdict and the offense with the personal circumstances could be taken into account and can result in a lower sentence.
Thank you.
Justice Gorsuch?
Not sure I understood that last answer. I don't doubt 3553A factors are very broad and give the district judge rightly lots of discretion in sentencing when there's not a mandatory minimum. But I wouldn't have thought that one of the circumstances, personal circumstances that a judge could take into account has, as Justice Sotomayor says, really nothing to do with the defendant. It has to do with the judge's own disquiet, perhaps reasonably so, about the jury's verdict. And I had thought in our legal system, the jury's verdict on the facts is not something a court can impeach unless it's clearly erroneous.
That's correct, Your Honor. And what I was referring to in answering Justice Kagan is that the judge here, for example,
Gorsuch
referenced
has a
the
background in
fact that the
defense.
defendant had no history of violence,
Sure.
that he was a working man, that he...
All of that's fair game. I agree with you. I'm not, again, I don't question any of that. But the appropriate remedy for disquiet about a jury verdict is to set it aside as beyond the pale. It isn't to say I disagree with the jury about the facts and therefore I'm reducing the sentence, is it?
Well, normally it isn't, but under 3582...
No, I understand your 3582 argument, but under 3553, that's not an appropriate consideration, is it?
It could be a consideration when weighing all the factors, deciding how much weight to give to questions like protecting the public from the defendant or the...
I think in that, protecting the defendant from the public, you have to take as given, again, the jury verdict. I don't think you get to impeach it by saying, I just disagree with it.
Right, but, I agree with that, Your Honor, but the question is how to weigh it.
Thank you.
Justice Kavanaugh?
Just one more on the role of the commission. Do you think the commission could, under 994T, say that claims of error in the conviction or sentence are not cognizable, are not extraordinary and compelling circumstances for purposes of these motions?
Yes, Your Honor. The commission has the discretion to decide what is within the meaning of the words and to take the position that certain things are off the table. Yes.
I think this is going to circle back to the Sentencing Commission needs to say something.
Wouldn't be able to challenge that.
That's correct, Your Honor.
Based on the questions I've already heard.
Thank you.
Justice Barrett? Justice Jackson?
So as I see
Deals
the question
with
presented as
compassionate
we've
release.
crafted it, we are not actually being asked in the context of this case to make a determination about whether a district court's disquiet or concerns about actual innocence.
I'll dumb it down really easily. This deals with compassionate release. Like it has to be extraordinary and compelling. Both things have to apply here, right? So you don't just get extraordinary. You don't just get compelled. Like, this deals with the conditions of like compassionate release and other things like that in accordance to some federal statutes that we have. This guy had a lot of stuff go on, and instead of like doing a victorious sentence and things like that, he went forward, he got a compassionate release, and then I believe it was the Second Circuit said, no, you can't do that, so they're reviewing this. That's this case really dumbed down for a second.
That the sentence or the conviction is unlawful. Here, the judge said the conviction is not unlawful. He made an express statement that he wasn't relying on any claims about the lawfulness of the conviction. He just had these other concerns. So I guess this is a long-winded question, but it worries me that we would have a rule that says anything that arises in the context of habeas can't be considered in this proceeding, because I don't know how you would do that from a workability perspective.
Your Honor, I agree there is a workability problem, and then there's also the perverseness of having claims that could not be brought in habeas would not fall within that rule, which I think is why the government went to a rule that it's only personal circumstances are allowed to be considered.
That was their way of solving my workability
I
concerns?
think that is, Your Honor, and there's no way to read that out of the statute.
As a life
Thank
sentence
you.
and a mandatory
Thank you, counsel.
life sentence.
Mr. Fagan?
Thank you, Mr. Chief Justice, and may it please the court. Section 3582C1A1 is a narrow exception to sentencing finality that allows a court to reduce a valid sentence in limited exceptional circumstances that aren't otherwise addressed by the criminal justice system.
So
I think what you've just heard and
people
what's in
bringing
their
the
briefs
case
is
say,
a proposal
no, this
to
is
make
a
it
lot
instead
broader than
an
people are
open-ended
saying. The
loophole
government's saying
to
not,
challenge
not. So
the validity of
broad
sentences
versus narrow here.
continuously through a potentially endless series of collateral attacks on the criminal judgment. The question whether a collateral attack on the criminal judgment compels relief is a question that's addressed by Section 2255, which draws a careful and deliberate line between finality and error correction. And yes, Justice Kagan, it's a strict line, and ordinarily a prisoner's claim isn't going to be compelling enough to meet it. But that doesn't mean that the claim can be wrenched out of context and, although procedurally and substantively deficient, can be used to create extraordinary and compelling
what I was
circumstances
talking about, the
that
justices were
warrant
circling the
reducing
wagons on,
a valid
is this a
sentence,
way
whether or not it's
around
window dressed with other factors
this other
that
thing?
aren't themselves
If you don't qualify for
extraordinary
this,
and compelling
now you
reasons
can do
that warrant
this.
a sentence
Is that what
reduction
this was
and would
created
be
for?
irrelevant under Section 2255. If you could do that, then it would really eradicate all the substantive, procedural, and temporal limits on Section 2255 claims and on collateral attacks on criminal judgments in general. And they say they can't find a single case in which that's happened. I think the court has one in front of it right now. It may be true that disquiet would get you, a claim of disquiet would get you nowhere under Section 2255, Justice Sotomayor, but I don't think that's to its benefit as a recycled claim under Section 3582C1A1. I'm sorry, Justice Thomas.
Mr. Fagan, there was some discussion earlier about several district court cases where the sentence had been reduced. Was the provision there, I think it was 4205G, is that the equivalent of the provision here, the compassionate release provision here?
It's not an equivalent, it's more like an ancestor to this particular provision. And so one big difference is that the exact language I was just referencing that requires extraordinary and compelling reasons that warrant a sentence reduction is language you'll see in the current statute and it's language from the original Sentencing Reform Act that wasn't in 4205G. But let me address the two cases that were brought up this morning. Banks is a case of rehabilitation, and that was the reason for release. And that's one thing we absolutely know for sure, and this court has several cases on this topic, that Congress was trying to cut off as a reason for release, and 994T will tell you that as well when it enacted the Sentencing Reform Act. The other case is Diaco, which was decided several years before the Sentencing Reform Act was enacted. With all due respect to the District of New Jersey, we're not 100% certain that Congress would have been aware of it. And frankly, we think it's wrong. And even then, it's a very exceptional circumstance where essentially what happened was another district judge went beyond that district judge's authority to grant relief to all the co-defendants of this one defendant, and without any other mechanism to kind of effectuate the original sentencing intent, which had gotten frustrated by ultra vires action by another district court. The district judge urged the BOP to file a motion to allow for early release on parole if the parole commission were to grant it, and the district judge in the case decided to grant it because it was, I think he viewed it as the least bad thing he could do to solve the rather unusual circumstance that came up there. But I don't think it's the camel's nose under the tent to allow legal claims. And just to answer one question you asked my friend on the other side, Justice Thomas, the word compassionate release actually is the title of the provision in the First Step Act that
I'll go look
enacted
it up.
the amendments to Section 3582
he's doing really well.
C that we're talking about, to some of which are
So
at issue
far,
today.
sometimes they
And I
start off
think
strong
the
and just kind of peter out.
2018 enactment of the First Step Act actually reinforces the original intent of Congress that this be for exceptional circumstances, not that it just be a loophole for Section 2255.
It does say exceptional circumstances, but it doesn't say solely personal circumstances. So I don't really know.
Y'all
I
can
mean, I
tap the
appreciate
screen.
the
I
government
appreciate y'all so
intuiting
much.
that. But we do have some indication that Congress was thinking beyond just personal circumstances from the legislative history. We have a case, and I'll find the case name in a moment, but in which Justice Scalia indicated that compassionate release might be available. You might know the case I'm talking about for an unusually long sentence. So where's the personal circumstances limit that the government is relying on here?
So I think there's a lot of reasons to think that, Your Honor. There's a lot packed into that question, or a few parts packed into that question. But first of all, I think the very language, extraordinary and compelling circumstances that warrant a sentence reduction, requires a court to look at the backdrop of sentencing law. It's not extraordinary and compelling in a vacuum. It's extraordinary and compelling reasons that warrant a sentence reduction. Second, I think there's a category mismatch when we're talking about these kinds of legal claims here, because as has been noted this morning, when you raise a Section 2255 claim, you're challenging the validity of the criminal judgment. And Section 3582C1A1, we talk about this in our brief, presumes that the judgment is valid, and it's about reducing a valid sentence. And there's kind of a category mismatch with taking a reason why the sentence is invalid.
But why doesn't that cut against you? That was the point I was trying to make to your colleague on the other side, which is that to the extent these are two different things, and that compassionate release assumes a valid sentence, and that you need to have it, or you're asking for a sentence reduction notwithstanding that, why then are we evaluating your ability to get one of those vis-a-vis what you could do in the other world where you'd be claiming that your sentence or conviction is invalid?
I think it cuts entirely in our favor, Your Honor, because it shows that these are meant for personal circumstances, because it doesn't really make any logical sense to reduce a valid sentence because of a procedurally or substantively deficient claim. The point of the claim being that the sentence was actually invalid. That is, you're taking, to use a slightly pejorative term, a kind of half-baked claim of legal error in a conviction or sentence and saying, okay, yeah, it's not quite there, but that's a reason for taking the sentence as a given and reducing it. That I don't think that makes sense, and that points again toward personal.
So essentially what you're hearing right now is it doesn't meet the criteria for this, so we're going to use this instead. That's the presentation here. It doesn't exactly meet the criteria to do X, so instead we're going to do Y, because Y will still provide a similar result, but doesn't take as much to get there. And can you do that under this?
I do think it is for changed circumstances, Your Honor. I think if you look at the legislative history, that's what Congress was anticipating. I think that's why the BOP filed these motions to begin with and continues to have a gatekeeper role today. I think we see that in 3582D, which are the notification requirements for the BOP, which require notifications in cases of terminal illness, which is actually kind of the canonical
Thank
example
y'all so
that Congress
much.
was thinking of. You can look at the original Senate report for the Sentencing Reform Act at pages 55, 121, and 173, if you want some evidence of that. And I think we find, and the other notification circumstance would be when someone is too medically or mentally infirm to file it.
I mean, there might be changed circumstances that are not personal in nature, that are in fact legal in nature. And so that there would be a divide between your personal circumstances line and the changed circumstances line. And the example I'll give you is, suppose the statutory construction, the way the courts interpret a given statute, have changed since the initial sentencing, such that somebody was sentenced to, let's say, a long sentence, and then the courts say, no, if he were coming up today, actually he wouldn't be found guilty at all. What do you do with that? Is that the kind of
That's
thing
a really
that can
good
be taken
question,
into
because
account,
is that extraordinary
under
and
this statute?
compelling?
No, Your Honor, it's not the kind of thing that can be taken into account, because that's something that's otherwise
It's about
addressed in the legal
compassionate
system.
release
And the
and
court
its
had a case about this a
application.
few years ago. It was Jones against Hendricks. And in Jones against Hendricks, the question was whether someone who had, or we didn't think he
Okay, but
actually
I
had
want
a
you to
valid
realize how
claim,
thrown off
but
this
who
sounds.
had a claim
The government
that there was a
completely
statutory error
reconsidered
in
how
his
you look at
conviction, but he'd
something,
already raised it once on 2255. Could get
I
relief
was
under
sentenced to
2255.
X
And what the
10
court said
years
in
ago,
Jones
but now
was
you're
no,
sentenced to
because
nothing
Congress specifically
under the
thought
same
about
crime.
when someone in that situation should
But
be
no,
able
that
to get
shouldn't be
relief,
considered an extraordinary
and
and
it
compelling
allowed relief
circumstance.
on a second or successive only
I'm
for
kinda thinking it
constitutional
should.
claims, not for
That's just a
statutory
personal
claims.
opinion,
Now,
not
on
a
their
legal
view,
one. But
Yeah, so that's right. The 22, you couldn't do this by way of a 2255 motion. Gosh, it does seem as though there a safety valve would be
Kagan
appropriate,
is freaking
given that somebody is
killing
serving
it
a lengthy
today.
sentence for something that is not a crime at
She's
all.
been asking
and
good
if we're sort of
questions.
thinking of this statute as a changed circumstances statute, not as a kind of general do-over for all your claims that you could have brought way back when, but as a changed circumstances statute, that would seem to me to be potentially appropriate.
Well, Your Honor, if Congress wants to allow a remedial mechanism for that, it would be free to do so. It could add and at points the department has either proposed or at least considered proposing a new 2255H3 that would allow that. It is the kind of claim you might be able to bring on a first 2255, and it would be, provided it were brought in time. And Congress can change the limitations on 2255 that it has. But it's drawn a line between finality and error correction, and I don't think it meant for Section 3582C1A1 to be kind of a loophole for whatever...
I'm sorry,
for whatever it had.
well, that's the problem,
limitations
is
it
we're
had
coming
imposed.
back to
Sorry,
this
Justice
loophole
Kavanaugh.
of they're
That was
circling the
not important
wagons
enough
on,
to
is
interrupt
this
you.
a circumvention or
It
is
was,
this what they meant?
Could the commission do that?
Could the commission?
Could the commission, under its authority under 994,
No,
Thanks,
I think this gets a little bit.
let me finish,
sorry.
do what Justice Kagan was talking about. In other words, your answer to Justice Kagan, well, Congress could do that. My question is, could the commission, under its broad authority, under 994T, do the same thing or not? And if not, why not?
No, we don't think that the commission in a post-Loper Bright world has the authority to make something that's not an extraordinary and
Not the
compelling reason
throwback
that
to
warrants a sentence
Loper
reduction
Bright.
into something that is an extraordinary and compelling reason that warrants a sentence
I don't
reduction.
know how Loper Bright affects that, but extraordinary and compelling are both
That was my
capacious
question.
terms that leave a lot of discretion.
I love it.
Let me give you a longer answer to this, Your Honor, which goes probably a little bit more to the next case. But first of all, it's just a pure question of statutory interpretation. If these words don't cover it, then the commission can't add them. Second, the commission's required to comply with all provisions of law under 994A, and they
Somebody
acknowledge
typed
that
something,
they
you got
actually
censored.
accept something from their new Rule B6 because it's covered by 3582C2, and they don't think they can expand on that. But even beyond that, Your Honor, the commission doesn't have just general authority to override general provisions of sentencing law, because the commission's
I'm going to tell you,
commission
a
isn't
good
the exclusive
90% of
interpreter
everything
extraordinary
you
and compelling
hear at these
circumstances.
is
Doesn't the statute
why the
make
fuck
them that
wasn't
in some way?
Congress
I mean, this
more
goes to a question
specific?
about the ordering and the
This is
steps
Jackson.
and what the government's view is about
Exactly.
how much judges have to defer to the commission's views on this.
When I
That's
tell you to
exactly where I
hold
was
your
going, Your Honor.
legislators
So if you look
accountable,
at
this
section
is what I mean.
3582 C1A1, you'll see that there's actually 2 threshold findings that a court needs to make before the court is going to be empowered to look at the 3553A factors and reduce the sentence. One of them is that the court has to find extraordinary and compelling circumstances, and the other one is that the court has to find that a reduction would be consistent with the policy statements of the Sentencing Commission. This court's decision in Coons against United States, I know there are 2 cases with similar names, I'm talking about the one with an S, addresses exactly identical language that appears in 3582C2 and calls it language of limitation. And I think it's even more so here, because the district court has to make an independent evaluation, even if there is a policy statement addressing it, of extraordinary and compelling circumstances. And of course, I'm sure petitioner would agree that the court has to make an independent determination of it, because otherwise, if there were no applicable policy statement, which is what the Second Circuit found in the context of petitioner's case, there would be no way to grant any sentence reductions at all, because
You'd certainly have to make an independent judgment where there were no circumstance or no policy statement. But I understood petitioner to agree with Justice Kavanaugh that if there were such a policy statement, the court would have to defer to it.
Well, if there were such a policy statement, Your Honor, it wouldn't change the structure of the statute. And the structure of the statute very clearly and explicitly lays these out as 2 separate steps.
Prove it.
So the court has to itself find extraordinary and compelling reasons.
Okay.
And then it has to see whether its finding or the other any of its other anything else it might do with regard to the sentence reduction. There are some additional constraints the Sentencing Commission has replaced on reductions are consistent with what the Sentencing Commission does. My point is that we know they're independent steps, and the reason that someone like petitioner was able, we think incorrectly, to get a sentence reduction even in the absence of any policy statement, that is the absence of any commission definition at all of what its view of extraordinary and compelling circumstances are, is that these are in fact 2 separate steps. So it's a particularly inappropriate circumstance to completely defer to the commission, because of course the commission is only telling us what it thinks are extraordinary and compelling circumstances for purposes of limiting the statute under its own policy statements when the court gets to that second step.
That was so many fucking
step,
words
if the commission
to say,
has not said
we don't
that
agree with
something is
this.
extraordinary and compelling. So in other words, it's been silent on it. It said other things are extraordinary and compelling, but has not said this is. Would it be permissible for a district judge then to say that such a reduction is consistent with the applicable policy statements? In other words, how do you read commission silence on the particular issue?
We read it as preclusive, Your Honor. We don't think that this could be brought today under the commission's current policy statement. I mean, maybe there would be some debate about that, but I don't think there would be much. I think it's always been understood that the commission's...
And that's kind of the end of it then for this case, isn't it, under your view? I mean, that's one way, that's the end of it, which is the commission has not issued a policy statement that authorizes or that suggests something like this is extraordinary and compelling, and that's an independent requirement of the statute, and that's the end of it? Is that one of your arguments?
Well, that's not going to be the end of this case.
Oh my God,
because it
commit
arose
to
when
it.
the policy statement wasn't in effect, so we wouldn't apply the policy statement to him unless
there's never been a policy statement that authorizes.
So does the lack of a policy
That's correct,
statement
Your Honor, but I don't think the court can
preclude
rest on
this
that as
or
a
allow
potential
this?
limitation to the loophole because, as we'll get into more in the next case, there's always the possibility that the Sentencing Commission could do that. We could have another period where for some reason there isn't a policy statement and then it becomes a free-for-all. There also is, and we think it's a quite limited one, there is a subsection B5 to the current policy statement, 1B113, which is an other reason statement, and we could imagine prisoners correctly or not trying to, we think incorrectly, but I'm sure they would assert correctly, trying to jam in what are their recycled 2255 claims under that. And the real problem with that, and this gets to something you were discussing with Petitioner's Counsel, Justice Kagan, is what we're doing is we're taking the limitations that 2255 imposes and we're replacing them with Section 3582C1A1 considerations to make some kind of Frankenstein monster that I don't think is what Congress intended. For instance, take your example of someone who misses the filing deadline by 3 days or 3 weeks or even 3 years. And the person says, well, okay, there is a doctrine that would handle that under 2255. It's equitable tolling. Now, I can't show you any circumstances that are sufficient for equitable tolling, but what I can show you is that I've really rehabilitated in prison, so that's the reason to let me out. That is nothing but a complete end around to a Section 2255 claim.
Again,
You
back
are
to
using
my original
the 2255
statement.
claim there as essentially
if it doesn't meet this,
sole
doesn't
reason
meet
for
this,
reducing the sentence,
is this a loophole?
except for rehabilitation,
The
which
government
is
is
the one
arguing
thing
it
we know
is.
Congress did
They're
not
arguing,
want
no,
to
this
be
is broad,
the reason that
so they
people
can
are
use
granted
it.
early release.
But I guess I'm trying to understand how your rule is workable in any real way, even with that example. So suppose you have an 80-year-old prisoner who has cancer. And
Okay.
I take it that your rule is that that's the kind of classic personal circumstance that can be considered in the context of compassionate release. But that could also be considered in the context of a habeas motion with respect to something like the tolling issue that you raised. So I guess I don't understand.
So does the
why
government
you're
get to
saying,
fight it because
or
they're
how
saying
you
you
could be
used it a
saying that
different
anything
way?
that comes up in the context of habeas can't be ever considered in this context. And maybe I have your rule.
We're not
I'm
saying
understanding.
anything that could ever be relevant.
Okay,
to
so what
habeas.
are you saying?
So I'm not saying, like, for example, equitable tolling, like I was in a coma, that could, I suppose that might affect someone's claim of illness under Section 3582 motion. Our argument is that something that would be grounds for attacking the validity of the original criminal judgment, that is, the kind of thing that would be raised as a Section 2255 claim. This would be the claim, not just some attendant circumstance to the claim that might be used for something like equitable tolling, can't be advanced as an
Even if you're not
extraordinary and
trying to
compelling
advance
reason.
it to attack your sentence in this context, even if you accept that your sentence is valid.
That's
and
right,
you
Your
would like
Honor,
it to
because
be.
by hypothesis, anything else the prisoner is alleging, for this question ever to make a difference, nothing else the prisoner alleges is itself going to be extraordinary and compelling enough. So what gets them over the line in these kinds of cases, in order for the question presented in this case to matter, the thing that gets them over the line has to be the Section 2255 claim. I don't think what Congress wanted was for someone to come in and have reasons that aren't enough to get them over the line. So the canonical example being rehabilitation, the court says no, and the prisoner says, well, here's my ace in the hole. It's a Section 2255 claim.
Fagan
now, it would never get anywhere
for the DOJ
because it's substantively deficient
this.
and it would be
Would
wildly
Trump
out of
pardoning
time. And I've already
everybody?
filed a
I don't
Section
know why they're
2255
arguing
motion.
this.
But hey, here's what I got. And if you add this to my rehabilitation, which is insufficient to...
Except, Mr. Fagan, what you're assuming is bad faith, really, because, and that's
Oh,
not
she
the
says
way
it
we
now that
function.
I say his name.
What you want is a rule that says not only if it can be brought in or should have been brought under 2255, but even if it couldn't have, but might have been, and I don't know how far your conflict articulation is going to go, then it can never be an exceptional circumstance standing alone. Well, nothing standing alone is ever an exceptional circumstance. Neither age nor medical condition standing alone qualifies you for a reduction does have to be extraordinary and compelling, and for that you need something more. So I understand in this case the argument that the judge's disquiet standing alone should not permit him to modify a sentence, that it had to have been with something else. And I can accept the argument that the something else wasn't much here, but you want a more absolute rule. And I fear that it...
I'll say this again for the people whining in the comments. If you don't like me talking during these, go to SCOTUS and watch it your damn self. Okay.
An absolute rule will be twisted and create its own nightmare, because there is nothing that standing alone is extraordinary and compelling.
Your Honor, that's not... The rule that we're asking for is the rule I was articulating to Justice Jackson, or at least attempting to articulate to Justice Jackson, which is that attacks on the validity of the conviction or sentence are excluded.
No, what you're trying to say is you can't even consider it. And that's what I'm asking you, is your rule absolute that way? There are circumstances where it could be one among many factors that lead a court to a sentencing reduction, as it can be one among other factors where the court says, no, I'm not going to do it anyway.
Well, Your Honor, I think first of all, I don't think there would be any kind of nightmare, because this is the way it has worked for the entire history of Section 3582C1A1 until the First Circuit decision in, I think it was 2022. So I don't think there is anything new. If anything, I think their rule would be very complicated and unworkable, because all of a sudden we would see any of the 5,000 prisoners
You haven't seen any of that there.
Your Honor,
I love the scare tactic, but I look for reality, and it just hasn't happened. And what I look at is the amicus who provides us with case after case, where courts are taking their responsibility very seriously. They're writing 50-page, 60, 70-page opinions, analyzing cases with extreme care.
You can block her, Davo.
And Your Honor, I think that's exactly the problem, because any of the 5,000 prisoners who file 2255 motions in a year could just keep bringing these same claims or new ones under 3582C1A1 and forcing district courts to respond to what are essentially new habeas.
We have plenty of ways to handle frivolous filings, counsel. We do it all the time.
The question is whether...
quickly.
I'm sorry, Your Honor. I think the question is whether Congress was trying to encourage the recycling or the renewal or the creation of
What we do know is that Congress was permitting sentences to be reopened. And in none of the words it's used does it put in any of the limitations that you're proposing. It does not limit this to personal circumstances, and in fact, the examples don't. It hasn't limited to only questions of fact and not law, which is what you're suggesting. And it has always included that there might be other reasons, and it's permitted the Sentencing Commission to define those other reasons.
Well, Your Honor, I think there is a very strong principle. I think Prizer and other cases are an example of it, and we have some of the others in our brief, that statutory schemes should be interpreted in a harmonious whole. And I think reasons warranting a sentence reduction points to that harmonious whole.
Except
and the idea
our heck line of cases make very clear that 1983 and 2255 are not invalid if there's a way to read both where the validity of the sentence and conviction are not challenged. And here, this is not challenging the validity of the conviction or sentence.
It's not.
It's asking for a modification under a separate statutory authorization, but it's not challenging the validity.
That's true.
The reason for the reduction is a challenge to the validity. Even something like...
No, but that literal, I'm going to pause it there, because that makes no sense. That line of thinking makes no sense, because even if his claim is valid, right, it's challenging the validity of this sentence. if it's used in the term of compassionate release, your sentence doesn't go away. Your sentence all it is a modification of your sentence.
Conviction and the sentence, but he didn't grant that. He did something totally different.
And
Thank
then,
you, Mr. Fagan.
Yeah, sorry, Your Honor. And then what he does do, and this is what we see in this case, is he eventually
Bruce Wayne,
grants
it can and cannot be all the time in the Supreme Court. It's freaking wild. This is my drama show.
Under his basis being disquiet with the verdict and
exactly,
sentencing
Nene.
disparities that are related to his disquiet with the verdict. And again, that is simply just a recycled and frankly non-cognizable
this is about
Section
compassionate release
2255
in
claim,
conflict
and
with
actual
habeas
innocence assertion
claims.
was made on 2255 before. And there's another
there's
another Section 2255 claim pending in the district court right now that makes the same assertion. I think another way to think about it, in addition to the kind of ace in the hole being a
We'll be
procedurally or
hearing another
substantively
case
deficient attack,
after this that it's
we'll
on the same
need to
grounds
wait for
as
another
this
day
case.
because I'm out of
It's
time,
all
Mr.
dealing
Chief
with
Justice.
compassionate release and how far does it go.
Justice Alito? Justice Sotomayor? Ms. Kagan?
So what you just said, Mr. Fagan, is one of the confusing
Kagan.
parts of this case to me, is that when I read your brief, the formulation of the
Those are
test
wild,
that you
too.
offer is, could the claim of error have been raised under 2255? And I have some sympathy for why that would be an extremely relevant question. But it just does not seem to be a question that applies in this case. Because here, as you say, we've never said that an actual innocence claim could be raised under Section 2255. So sort of the premise of your argument, which is it could have been raised in 2255, sorry, you lost your chance. But the premise of the argument is it could have. And here we don't really know that it could have. The court has never said whether it could have. So the rule doesn't really seem to fit the case, if you understand what I mean.
Well, 2 points, Your Honor. You might, I think, more usefully use the formulation that it would be a claim that or an asserted reason that attacks the validity of the conviction or sentence, and I think this one would fall into that. And when we talk about Section 2255
So there is a real
claims,
difference between that formulation and the one you most often give in your brief. So you're now switching from the one you give in your brief to saying, does this attack the validity of the conviction?
Well, we said both in our brief, Your Honor, and to the extent we're focusing on Section 2255 claims, I mean, frankly, that's largely as a result of the court-written question presented that we were trying to work within, which
She
I
said
assume
you didn't put that in there.
kind of was written in a way the court intended to apply to this
I
case.
love this.
But the second thing I'd say is, to the extent you would include things that would attack the validity of the conviction or sentence, like a
Sorry,
claim
guys,
of
I'm still getting
disquiet,
over a little bit of a
that
cold.
just aren't even substantively meaningful enough to get past the first marker on Section 2255 claim, that's all the worse for prisoners in this position. So I think you would write it a bit more broadly. But I would take this as something that could be alleged under Section 2255, and it would simply lose. I think it would make absolutely no sense to have a rule that if you could win, or you could have made your claim under Section 2255 and it would be substantively valid.
He thinks it would make no sense. Does he have evidence that this is not what Congress intended? It's not about what you think makes sense. It's about how does it apply.
Then you're precluded, but if you would have had a substantively invalid claim, you wouldn't be.
Okay, thank you.
Justice Gorsuch? Justice Kavanaugh?
Just so I have the government's position clear, where does a prisoner go who has a claim of actual innocence based on newly discovered evidence?
So, as this court has explained in, among other cases, Herrera against Collins, if you have a claim of actual innocence, it's got to be paired with another constitutional claim. Now, Congress has made an exception in Section 2255.
So I think your answer there is nowhere other than a pardon.
Well, you could, if it's paired with a claim of constitutional error.
If it's not paired,
If it's not paired with a claim of constitutional error,
So one of the
I think
biggest
it's going to have
problems
to be
in our
addressed through
system
the
is
clemency
that
procedure.
Thank you.
it's very hard
Just
to
to
like
follow up on that
appeal
point,
your-
Mr. Fagan,
Barrett,
would the idea
she
be
hasn't
that
talked
if an
much.
actual innocence claim, a freestanding claim, is not available under 2255, it's because Congress has implicitly precluded it by not giving a route to raise such a challenge under 2255?
Well, I think there are a couple of reasons. First, I don't think Congress has disturbed this court's. This court has never squarely addressed whether there's a freestanding claim of actual innocence, and I think if the court were to, contrary to the skepticism, I think the court. I read in the court's opinion in Herrera against Collins, the court were to decide that such a claim exists, I don't think Congress has precluded it under Section 2255.
Generally,
But if
I don't
it's not
agree with all of her
an
takes,
existing
but I like her
route
as
to
a justice.
post-conviction relief, then I don't think it can be read into Section 2255. That is, Congress wasn't trying to create some new ground for relief. Congress did enact Section 2255H1, which kind of mirrors the actual innocence exception as a reason why someone, as a showing that a particular prisoner could make to bring a second or successive claim that would otherwise be precluded. But I don't read Section 2255H1 to authorize that kind of claim as a freestanding claim divorced from constitutional error.
This is
I think
specifically
what
to
it
federal
does is
prisoners.
if you can
State and
meet
federal-
the
there's
actual
two different
innocence
ways that those are
bar,
handled.
it is allowing a second or successive claim that relies on some constitutional
Yes, Louis,
ground.
I guess I'm just trying to figure out how to articulate the rule. I mean, you offer
Do I
one
think
way
there were
if
better
we say that
choices?
if you're going to
Sure, but
challenge the
I do
validity
think
of a
she's a
conviction
highly
or
qualified
sentence,
judge.
2255 is your option. You know, that rule I can see making sense. Otherwise, it feels like we would have to decide if we peg it to 2255 very specifically, like if you could bring this, if this is a cognizable claim under 2255 and you can't raise it under the compassionate release statute, it seems to me that we have to decide whether an actual innocence claim in a freestanding way is available under 2255, which I take Justice Kagan to be pressing you on.
That's why I'd go with the other formulation, Justice Barrett. And in answer to both you and Justice Kagan, if this helps, we don't really conceive of those things as being different. Section 2255 is the vehicle for raising claims or challenges to the validity of a conviction or sentence. So I think the phrase Section 2255 claim one might think of as something that has some chance of succeeding if it's brought at the proper time. I think the right way to think about it in this context is just the type of thing that is the proper office of Section 2255. And the space that 2255 fills, the role that it fills within the sentencing scheme is it's the place you go when you have a challenge to the validity of your conviction or sentence. That place is not 3582C1A1. There's no way that Congress wanted the BOP originally or as the gatekeeper now or district courts to be relitigating claims of actual innocence under Section 3582C1A1, let alone just a mere argument about disquiet.
Justice Jackson?
I guess it seems to me that that argument really only works if that is the only concern in the 3582 world. I mean, what if we have the 80-year-old defendant who has cancer and other ailments, and there's this concern about whether or not his conviction is valid? Why would the government say that that couldn't be part of the overall analysis if there's more than one factor?
Well, I think there's two reasons for that, Your Honor. One is one I was suggesting earlier, which is that if you have other claims, and I just taking your hypo, I will assume for the sake of argument that those other reasons would not themselves be extraordinary and compelling.
Well, I mean, Congress has said in 994T, like even when it looked at rehabilitation, it just said it can't be used alone. It took it off the table in its sole form. And I guess I just don't understand why the government isn't doing that sort of thing as opposed to saying you can never look at it.
So I have two answers to your question, Justice Jackson. I mean, the first way to look at it is assuming those other reasons are not sufficient on their own, like you gave the 80-year-old and she has cancer. If that weren't enough.
Yeah, it's literally right here. The sole limitation Congress placed on That discretion is found in 18 U.S.C. 944T, which provides that rehabilitation of the defendant alone shall not be considered an extraordinary and compelling reason. Her point is incredibly valid here. It doesn't mean you can't consider rehabilitation. It only means that you cannot consider it as the only reason.
Thank you, counsel. Rebuttal, Mr. Groenstein.
I'd like to start by talking about a question that Justice Kagan asked, whether the government's position would be workable. And what the government's position to exclude habeas-like claims would require would be an analysis in each case of whether a claim could be brought under habeas. And what the colloquy about actual innocence shows is that that's not always an obvious question. And to the extent a petitioner under 3582 could not raise actual innocence, which seems to me like it would be the ultimate extraordinary and compelling circumstance, shows how the government gets things backwards. The government ultimately tries to deal with the unworkability problem by saying that the rule really is personal circumstances. Not only is that nowhere in the language of the statute, but clearly cases will fall through the cracks. The Setzer case is one of them, where the court considered using 3582 to deal with a state sentence that was not that was going to run consecutive. Also, of course, the cancer patient that Justice Jackson referred to. If someone had cancer and was serving a 30-year sentence and had 5 years left to live, it certainly should be relevant that the conviction that he had was no longer valid or would not be
it's
valid
just more
today.
Compelling evidence.
The only reason to read the statute in a way that is not according to its literal terms is if there's another statute that conflicts. The government talks about how these issues are otherwise addressed in the legal system. That is not the test. The test is whether there is an irreconcilable conflict and whether this reading of 3582 would wholly frustrate the habeas statute. That's what Jones v. Hendricks was, where allowing a 2241 would entirely undermine the 2255 restrictions. As to Justice Sotomayor's point about the work that judges are doing in these sorts of cases, judges are doing very comprehensive work, and it's not surprising because this is very similar to the work judges do every day in sentencing when they are previously looked at heartland departures. They look at what makes this case extraordinary, and judges are well suited to do that, subject to to review by courts of appeals. And finally, I would, as to Justice Kavanaugh's point about the commission not speaking yet on this issue, I think it's relevant to go back to the language of the statute first, which is the words are extraordinary and compelling. They are, in Your Honor's words, capacious. They leave a lot of discretion to the district courts. But there's another very important feature to the statute, which is that there's a delegation to the sentencing commission to, if there are things to be taken off the table, if changed circumstances should be the touchstone, that is for the sentencing commission.
Thank you, counsel.
Thank you, Your Honor.
The case is submitted.
Okay, we have another one coming up after this. I will change my background. Give me just a second. We're doing both of these today because they both pertain to compassionate release, how they apply, circling the wagons, so this is my last one for the month, unless something crazy pops up and has to be done immediately. I will be back December 1st. All the cases in December are pretty much a banger. There's very few boring cases. So we're excited for that. Does anybody have any questions that I can answer? As far as I know, they won't go on break, but I've been burned before, so we'll see here in a minute. But I think they'll hear this next case here in a minute.
Folks, once again, if you are staying, please have a seat. Thank you.
Oh, Lord. Okay, yeah, they're going to go to the next case here in just a second. First opinions. We've gotten some as early as this month, December-ish, so we just don't know. But when opinions come up, I'll try to do lives to sort of explain them, but yeah. What the fuck are you talking about, Angel? This had nothing... Shut the fuck up. Anyway, that's not what this is about. But yeah. So this one is also
Your argument next in case 24-820, Rutherford versus United States, and the consolidated case. Mr. Frederick?
Thank you, Mr. Chief Justice, and may it please the court. The 1984 Sentencing Reform Act confirmed that district courts have broad discretion to consider relevant information in imposing and modifying criminal sentences. Section 994T limits only one category of information in compassionate release cases, rehabilitation alone. Section 3661 otherwise imposes, quote, no limitation on the information a court may receive and consider during sentencing. The Third Circuit, however, imposed a judicial limitation on compassionate release. It precluded district courts from considering a change in law that prospectively lowers sentences for offenses like Mr. Rutherford's as one fact in the total mix of information for sentence modifications. That categorical limitation should be reversed. The government concedes that age and illness are ordinary circumstances for inmates. Yet when combined with other factors, age and illness may be extraordinary and compelling in appropriate situations. Whether a change of law is ordinary, therefore, should not matter. Congress did not expressly limit that as a factor in considering modification of extremely long sentences. The court should reject the government's contention that the 2018 First Step Act impliedly repealed the many provisions of the 1984 Act conferring broad discretion on district courts. I welcome the court's questions.
Mr. Frederick, it was Congress's choice not to make this retroactive. And it would seem rather odd that you would want to use that decision as a basis or a compelling reason to reduce a sentence that results from the prospective nature of the law.
What Congress did in Section 403B of the First Step Act, Justice Thomas, was to apply it to pending cases. Release. But Congress did not speak to the question of how that rule might apply in the 3582 situation. So Congress was silent with respect to that. It was, as I acknowledge, with respect to pending cases, a narrowed rule about limited retroactivity. But that just means that Congress was leaving to the individual decision-making process in these compassionate release cases up to the discretion of the judge, looking at the totality of the circumstances, whether or not the length and duration of a sentence and a disparity might be a relevant circumstance for that particular inmate. I want to point out that the government's principle here is an atextual one, as that came up in the previous argument. Its idea about personal circumstances is nowhere found in the statute, and the idea of extraordinary and compelling depends on the changed circumstances that arise after the person has been sentenced. Justice Kavanaugh, in the earlier case, you inquired about the Sentencing Commission, and I want our position to be very clear about this. The Commission has spoken to the situation that is in Mr. Rutherford and Mr. Carter's cases. If the Commission reversed its course and took those changes of law that are prospective for unusually long sentences, we would have to respect that decision, because Congress said that for a compassionate release motion, it had to be done consistent with the Commission's policy statements. So under your hypothetical, as you posed it in the previous case, we win our case. We could lose if the Commission were to change its position.
You win if Justice Thomas's point, though, doesn't make the Commission's judgment inconsistent with the statute. Now, you have an answer to that, but there's an if, I think.
By the way, both the people in these cases, this involved armed robbery.
I'm happy to provide that answer, which is that Congress didn't intend to take the Commission's discretion away,
in particular to
when
cartels,
it never addressed the issue of how compassionate release motions should be treated in this gun situation when they're taking the stacking away. And it certainly has a profound effect on the one issue we know Congress wanted in compassionate release cases to be considered, length of sentence. The whole idea of compassion, obviously, is to bring compassion by lowering the amount of time that a person is incarcerated. And so it makes logical sense that if you're going to consider any legal change, it would be one where society has demonstrated a will to decrease the amount of incarceration time for persons who might be subject to that kind of principle. And that makes sense for the totality of the circumstances the district court would be obliged to take into account in looking at the other individual circumstances that are relevant for the person. Mr. Chief Justice, you raised the question about kind of a floodgate of problems, but let me address that by saying there are three institutions that are relevant here. There's obviously the Sentencing Commission, which takes into account data and looks at real cases. There are district courts that are entrusted with dealing with these kinds of factual matters all the time. And then there is appellate review under an abuse of discretion standard. Appellate courts have exercised the reversal power under abuse of discretion where district courts have gone too far. And I would point the court to a Sixth Circuit case called United States versus Bass, in which the Sixth Circuit said the district court had gone too far in the post-COVID situation because it allowed for the reduction of a sentence of someone who had been committed to life imprisonment for committing several murders and involved in conspiracy for other violent acts. And the Sixth Circuit said that was an abuse of discretion. So our view is that although there may be some motions filed, and in the fiscal year 2025, approximately 2,000 motions for compassionate release were filed, only 56 were granted under this B6 provision. That statistic is in the clinical law professors.
Okay, so let's think about this for a moment. Thousands of petitions filed. Only 56 of them got this type of release. And he's also saying that appeals courts have a way to remedy if there was some abuse of discretion there. So you gotta wonder what's going on.
Is it the plus factors that then would prevent it from becoming a huge loophole?
Justice Barrett, these are always combination of factors. No one factor, I think, arises to the level that it would by itself be extraordinary and compelling because the word reasons is in the statute. So it's got to be multiple reasons. Our client, of course, as you noted, had a very good rehabilitation record, has health issues, has family circumstances where if his earlier release would enable him to help find and provide for his deceased sister's children. So these are the kinds of circumstances that a judge reasonably would take into account.
Could a judge, let's say before the First Step Act was enacted, say that in my judgment,
this goes
I
back
really
to when
feel
they
like
were
these are
saying you
excessively
can't
long
consider
sentences
rehabilitation
and
alone,
treat
but
that,
to not
the judges,
consider
let's
it
just say
at
it's
all would
disquiet
also
about
be
the
crazy.
legal penalty that Congress has chosen to impose. Would that be an extraordinary and compelling reason, or is it only the subsequent change?
Length of sentence is a factor, and it always has been a factor. And we know that because the Diaco case, the Bureau of Prisons, represented by the Department of Justice, came to court and said the long sentence should be reduced because of these disparate circumstances. The Senate...
Well, no, I'm just saying, just based on the judge's disagreement, the judge's disagreement with the length of sentence that Congress chose to impose as a mandatory minimum.
Mandatory minimums have long been thought to fall within the rule of compassionate release. So has life imprisonment, for that matter. And the Department of Justice agrees with that observation, filed a brief a couple of months ago in the Sixth Circuit in a case called Stricker, in which it took that position. So that is not an unusual feature of how compassionate release works, and that makes sense.
Mr. Friedrich, I'm hearing Justice Barrett's question differently, and she'll correct me if I'm wrong. I think her question is, standing alone, could a judge use their unhappiness with mandatory minimums to grant compassionate release?
No.
That would be, I think, an abuse of discretion, because the mandatory minimums set forth by statute indicates what Congress's judgment is. The extraordinary and compelling reasons are almost always plural. And in fact, the form that...
But even if it weren't plural, could the judge take disquiet or disagreement with the statutory scheme prescribed by the statute as one of the reasons?
Certainly the judge, in looking at the range of factors, would take into account that person's experience in looking at like cases to determine whether
Just
there's...
answer the
just
question.
saying disagreement. You keep going to disparity. I'm just saying just disagreement. I think Congress has been too harsh here.
I think a judge is certainly not within his or her discretion to disagree with an act of Congress. Where I think that judges have addressed this particular issue and where the Sentencing Commission addressed this particular issue was to say that in the total mix of circumstances and information, it could be a factor. And it is certainly a factor that we would want to take into account because the whole idea behind this provision was as a safety valve against unusually harsh and long sentences. The length of sentence is the key fact in all of these
Mr. Frederick, I'm not sure I understood your answer to Justice
You're
Barrett.
not
Is it
giving
a
a clear
permissible
answer,
factor
and that's the problem.
for a judge
You don't get to take your personal beef
include
with a mandatory
in
minimum and apply it
determination,
to that discretion?
disapproval of the mandatory minimum?
A judge would be committing an abuse of discretion to disagree with a policy judgment made by Congress.
Why did
However,
it take a man explaining
a judge
this?
would also be within his or her discretion to say that for this particular inmate, given the circumstances here, this minimum would be subject to compassionate release.
I don't quite see the difference between those two things.
Because
the difference, Your Honor, is that we're looking at the totality.
they always start out so strong and then they crash and burn because they don't want to make a point and commit to it. It is okay to say that you can't just be mad at mandatory minimums and make a discretionary call off of that. It's also okay to say, like, given all extenuating factors that we consider, this isn't proper, like, fucking, I swear to God.
The part of where I'm going to challenge your question's premise a little bit, Justice Alito, if I might, is that where you say in all circumstances, because the judge is always looking at the one case before.
Okay, so the judge, there's a case where the mandatory minimum is 10 years, and the judge says, I know that's the mandatory minimum for the run of cases, but in this particular case, I think for a variety of reasons having to do that's too long. That's okay.
Well, if your question is about original sentencing, I think that's different.
No, on this
modification.
Motion, on this modification.
If under your hypothetical, the person is 75 years old, has a life-threatening disease, and the court says, this mandatory minimum is pretty harsh, and the BOP is likely to be coming back here to say we don't have the medical
broadly
facilities to deal with that person.
misinterpreting
It is
the
not an abuse of
direct
discretion
question
for the court
nature
to
of
say,
this.
in this particular circumstance, that mandatory minimum is too harsh.
Thank you, counsel. Well, just to continue the line of questioning briefly, well, you really shouldn't call it a mandatory minimum. Then you probably should call it.
I will be
like the
right back. I have got to go to the
minimum,
bathroom and
depending
grab
upon
something to eat real
subsequent
quick.
developments.
Well, it's not for me to offer up words to Congress that Congress wrote in its statutes, Mr. Chief Justice. What I would say that as a practical matter, compassionate release is the rare circumstance where as a safety valve, the court takes into account the total mix of information in determining whether a downward adjustment in the length of time that the person incarcerated should serve.
Well, in second guessing the judgment of Congress.
Well, Congress also has delegated this authority to the Sentencing Commission, and the Sentencing Commission has issued policy statements that speak to this very question that's at issue in our case, and district courts have exercised their discretion in compassionate release cases to deal with the mandatory minimum concept. And so there's law on this.
Okay, sorry, y'all.
If disquiet about the mandatory minimum is a permissible factor so long as it's linked with something else, do you think there are going to be a lot of cases in which defense attorneys are going to be totally
Angel,
unable
calm
to
your
come up
ass down
with
in the comments.
some other
We're
thing
listening to
link it.
arguments. Shut the fuck
Well,
up.
Justice Alito, I would say that we do have experience with this question, that the Bureau of Prisons does have a form that the prisoner has to fill out and go through an administrative exhaustion procedure before even going to court.
No, you
And
can
that
leave if
those
you don't like it.
factors are baked into the facts before typically a lawyer even gets involved in filing a motion for compassionate release in the district court. And district courts are free and have just denied 85% of these motions.
Justice Sotomayor?
You presented your arguments slightly different than Mr. Carter's attorney, but I don't want to move away from the fundamental question here, which is this.
I love
your
everybody
client's
coming in. Thank
situation
you so
is
much. If you
consonant
can just continue to
with the
tap the
Sentencing
screen.
Commission's policy statement, correct?
Yes.
And so
Appreciate
we
all
would
of
have
you.
to find that the Sentencing Commission exceeded
This is
or
obviously
violated
Sotomayor.
the statute. Why don't we deal with that? Because they're not saying disagreement with the mandatory minimum is enough to get a change. They're putting other qualifications. Why do those qualifications count as individual?
Because they're extra-textual. The Congress made very clear in the 1984 Act, and that's why I would urge the court to consider the intent of the 1984 Congress, which delegated this authority to a new creation, the Sentencing Commission, and it said we want the commission to come up with an explanation for the extraordinary and compelling reasons that would underlie the inmate's compassionate release motion. And the commission, after some period of time, has done that. We now have a policy statement. That policy statement is consistent with our position. The extraordinary and compelling reasons do not have to be tied solely to the personal circumstances, although how long a person is being incarcerated is a personal circumstance for everybody who thinks about it. And so the commission's role here is to interpret those words. It has done so. Our case fits within those structures within the commission's policy statement.
And why is it not a violation of the statute?
It's not a violation of the statute.
The government says it is, basically.
Well, we'll hear more, I'm sure, about why the government thinks that, but it is not a violation of the statute because Congress made this delegation to the commission. It entrusted an expert agency, if you will, designed to collect information, talk to stakeholders, get district court input, et cetera, and render a policy statement. And in fact, the commission's work here is a little bit narrower than if you were to take just simply the plain language of extraordinary and compelling in those words by themselves.
Justice Kagan?
Mr. Frederick, if your position were accepted, would the inquiry in a case like yours look pretty similar to the compassionate release inquiry in a crack cocaine case, where there is consideration of the change in law that occurred in that area?
Not necessarily. And the reason is that in the crack cocaine context, there was a retroactive application and a categorical context. And we know what that did to the system because the federal defenders and prosecutors had to get together to design mechanisms for informing district courts about how to deal with that. Here, because we're dealing with a changed circumstance for the gun offense, we're typically dealing with inmates who have a proclivity to do violence, likely did do violence in prison, violated their rehabilitation terms and other terms of incarceration. And so their individual circumstances, when viewed from the total mix, are almost certainly going to be different in most of these cases.
Thank you.
Justice Gorsuch?
Mr. Frederick, I want your help with what the Sentencing Commission has said, put aside whether it can say it. It said that you should assume a change in law applies retroactively when Congress changes a law. But it says you cannot make that assumption with respect to our work in the sentencing guidelines unless we say so expressly. That seems to have things a little bit backwards, doesn't it?
Justice Gorsuch, I would say that there are inconsistencies throughout this particular area of law that create conundrums for district courts to have to grapple with.
This is a conundrum for us, I think.
I appreciate that. But what I would say is that in the particular circumstance that we have here, we're not talking about a retroactive application in any kind of guise. You can reserve on that question and say whatever the commission.
You want us to look at a change in law and assume Congress wanted us to do that, right? And the commission's saying, yeah, go ahead and do that, but don't do it with respect to our work. And that seems rather disrespectful of Congress's work and rather solicitous to its own.
What I would say in the compassionate release circumstance, and that is different than the or normal application of the sentencing guidelines, which are guidance to district courts in doing their sentences. And the reason why the commission would apply a rule about non-retroactivity in the initial sentencing is that it really will royal pending cases in a manner that would create more administrative burden. Our proposal here for compassionate release doesn't do that.
Well, that gets back to all the questions we've already had about whether or not this opens up floodgates. And I guess I'm less concerned about that than again, just the solicitude that the commission shows to its own work, but not Congress. And if you could address that.
I'm not here obviously representing the commission, but what I would say is that there are administrative reasons why the commission would determine that changes in its own guidelines or policy statements would create more uncertainty in application than where you were to take an idea that with someone incarcerated like Mr. Rutherford for 42 and a half years for a sentence that should be 18 years less, you might come to a different conclusion.
Thank you.
Mr. Kavanaugh?
Just pick up on that and Justice Thomas's original question, because the separation of powers issue concerns me here a bit, which is the First Step Act was obviously heavily negotiated and very carefully, a lot of back and forth on that. And retroactivity is, of course, always a key element of the negotiations, as it was here when you are making a change in the criminal justice and criminal sentencing laws. And so Congress specifically, I think, says this is not going to be retroactive to those cases where sentences have already been imposed. And then the commission, though, then comes in and says we're now going to give a second look for district judges to revisit those sentences, even though Congress in those sentences did not want them made retroactive. And that seems to be, obviously the commission was very divided on this question, and the commission dissenters said this is a seismic structural change to our criminal justice system that countermands Congress's judgments. And that's my concern on this case, and I just want to
Congress
give you an
said one
opportunity again
thing,
to
the
summarize
sentencing commission said
why you
nah,
don't think the commission,
and we
by
got a problem.
doing this, is kind of countermanded Congress.
There is certainly a huge difference between a categorical application of the rule, which we know from the crack and powder cocaine context, and a more limited case-by-case totality of the circumstances inquiry where you look at the effect of the stacking of the gun charges on the length of incarceration. And I think it's reasonable to suppose that in the context where you're dealing with a categorical change that has a very large systemic effect, and amicus briefs on our side point to all the steps that had to be taken, none of those have been taken and need to be taken in the 924C context. And the reason for that, Justice Kavanaugh, is that we're looking and we're trusting district judges to look at this on a case-by-case basis to decide whether or not a sentence reduction is warranted in light of the totality of the circumstances. That kind of inquiry.
Do the disparities there worry you? Some district judges are going to treat this wildly differently than other district judges one imagines, in the same
this
courthouse.
is a 4-6 split in the circuits right now, so
ought to be
this is
concerning
actually
to reasonable
an interesting
people,
divide.
where I think
They're
that
pretty split.
it is an inherent part of the system of sentencing that's been part of our system for 200 years.
Sure.
It's impossible to say there's complete uniformity, and when you do, then we had our own problems with that uniformity.
Justice Barrett? Justice Jackson?
So I think you're saying in response to Justice Kavanaugh that this isn't disrespectful from the Sentencing Commission's perspective because it didn't take Congress to be removing the ability for individualized consideration in particular cases.
That's correct.
And with respect to Justice Barrett's point about how this would operate with respect to a judge who had policy disagreements with a mandatory minimum, I guess I didn't take your argument in this case to really be about that at all. And by that I mean, I thought what you were focusing on in this case is the fact that there's a sentencing disparity that has been created such that your client, if he was sentenced today, would not have the same sentencing exposure as Congress now has determined it, because Congress has changed the statute. So it's not the court saying, I don't think people who do this sort of thing should be subject to this length of sentence. It was Congress who said that in this.
Yeah, Congress changed it. They said, we're taking away this, and somebody who was sentenced to 40 years, 20 years ago, well, today, if they have the exact same charges, exact same conditions, can only be sentenced to, say, 10 years. Is that extraordinary and compelling? Does that apply here?
People who've done this sort of thing should get.
Ari.
Yes, and doing it, though, in a contextual way that takes into account the various circumstances of that inmate's behavior in prison, age, illness, family circumstances, and the like.
And so in some sense, the compelling circumstance here is that the change, this is kind of going back to Justice Kagan's point in the first case, that there's been a changed circumstance with respect to how long Congress believes that people in this circumstance should be sentenced. And even though Congress didn't necessarily want that to be applied categorically, there's nothing to preclude courts from taking that into account in an individualized way in combination with all sorts of other factors if a person requests it.
That's correct. And the 1984 Congress used the words that enabled that particular outcome, Justice Jackson. And I would just note in the original appeal, Judge Ambrose affirmed the sentence, but said it's unthinkable that in any system the sentence should be this long for the two robbery offenses that my client committed.
Can I just ask you one other thing? Because I noticed that there are differing views about the order of operations, just as a practical matter. The judge who was trying to entertain a compassionate release motion.
I've got somebody at my door.
I think it might matter because sentencing disparities are actually prescribed by Congress as a consideration in 3553A. So if you have to do 3553A, then you're going to take into account the kind of thing that the government is now saying that you don't in the extraordinary and compelling circumstances world. So what I mean is, what is your view of how this works? Lower courts, I think, are starting with the extraordinary and compelling circumstances factor with the Sentencing Commission's guidance, and then they turn to 3553A. The government seems to suggest that you start with extraordinary and compelling factor without the Sentencing Commission's guidance, then you go to 3553A, and then you consult the Sentencing Commission as a check or a limitation. But the statute suggests there's even another way of doing it, which is that you start with 3553A, and then you go to extraordinary and compelling with the Sentencing Commission. So what's your view on the order of operations in this?
Justice Jackson, I confess that it has been a while since I did sentencing cases in the government, but I would say reading this particular statute, I don't know where this 2 or 3 part step where you just start negating things if they don't meet a certain threshold. The statute is worded as if certain things happen, then such and such. And that to me suggests that this is a gestalt. It is a totality of circumstances kind of inquiry. Which order you do them in, we trust district judges to get to the right outcome based on those circumstances.
And you admit that you see that 3553A does require consideration of unwarranted sentencing disparities.
Yes.
And it's in this statute too.
Yes, and it seems odd that you would say, Well, we're only going to consider it one if we've nuked you out of a position to be able to bring that argument based on considering a different factor.
Thank you.
Thank you, counsel. Mr. O'Neill?
Thank you, Mr. Chief Justice, and may it please the court. I'd actually like to begin directly with Justice Gorsuch's question about the language and the carve-out that you referenced in the commission policy statement. There is very good reason for that carve-out, and it does not show disrespect for Congress. In fact, it shows the opposite. There is a separate statutory provision, Section 3582C, that specifically deals with reductions based on changed sentencing guidelines.
This is the
and that
same
requires
order from
in Section
before.
994U specific findings that the commission needs to undertake. So in response to public comment during the very robust process that the Sentencing Commission undertook, the Sentencing Commission thought it was necessary to clarify how its guidance in B6 relates to that other guidance, which is set forth separately in Section 1.10. I'd also like to address, Justice Kavanaugh, your question and the one that Justice Thomas started with, because I think it is the essential argument for the government's position. Their argument is that B6 conflicts with the retroactivity provision of the First Step Act. There is no conflict. Section B6 does not purport to make that law retroactively applicable to to defendants serving final sentences. Instead, it addresses a fundamentally different issue. When courts conduct an individualized assessment of a prisoner's circumstances under a separate statute, the question is, does the court have to blind itself to one factor, sentencing disparity, even though that factor may be highly relevant to the court's assigned task? We don't claim that our client could come in here under 403A and seek relief. But all that the commission instructed, all it decided is that courts may, in their discretion, take that factor into account. But they didn't, but it allows that only in narrow and unusual circumstances. I also think it's very important, Justice Kavanaugh, to recount how we got here, how this issue arrived with the commission and how it arrived at the court. So after Congress eliminated BOP's role as the gatekeeper in the First Step Act, courts began to address prisoner-initiated motions of the kind that Congress allowed. And the courts disagreed about whether consideration of legal changes should or should not factor into the equation. Divided into two camps. One camp said these should always be taken into account, and the other said they should never be taken into account. The case came here, this court denied cert after the government said this is the commission's job to address. The commission undertook that process. It was perhaps the most, the public was as interested in this issue as it had ever been in any issue. And the commission adopted a middle ground. It didn't adopt the you can always consider these. It didn't adopt the you can never consider these. It said you can consider them, but it responded to the government's concerns about administrability by putting in a 10-year bar before you could seek relief. And it required this multi-factor test that incorporates the Section 3553A factors. So in fact—
Mr. O'Neill, how long was the Sentencing Commission, how long did it consider this?
I believe that this was over about a 6-month period.
Okay. And I understand your point about, well, the commission, before it's going to make something retroactive, has certain hoops to go through. I get that point, and I appreciate that. But retroactive application of federal law also has some hoops to go through, and they're usually, we think of Congress doing those. And the evidence we have here is 403.
Frederick is the counsel of record for
it says it
Rutherford,
shall apply.
O'Neill,
tells us
for
exactly when it
Carter.
applies.
So
depending cases.
We're going to be hearing from both of them.
Okay. Where no sentence has yet been imposed. And then with respect to retroactivity, it tells us it shall also apply to those drug offenses in 404B. That seems like Congress thought pretty hard about this, to Justice Kavanaugh's point. And it is a bit of a leap to say, oh, Congress didn't think about this. And retroactivity of a criminal law in a sentence, it just failed to consider it. It seems a plausible possibility, but perhaps a little disrespectful?
No, Justice Gorsuch, the question that Congress was considering in 403 was applicability to everybody. So does it apply to everybody moving forward? And does it apply to everybody moving back? Retroactivity would have meant that every defendant who had committed an offense before the act would have
pretty clearly ruled out, right?
We agree that is ruled out.
Okay.
Mr. Carter, because he is not in that class, he cannot claim relief under Section 403A. But Congress said nothing about whether the impact of those changes could be considered in the context of entirely separate.
I understand that, and we're having to draw an inference, but boy, Congress spoke pretty clearly to retroactivity in 403 and 404.
So, Justice Gorsuch, I make 2 points. First, even the government agrees that these changes actually can be taken into account, even for defendants serving final sentences. So the government agrees that when you get to what it calls the sentencing determining phase in this two-part
a textualist
stage
what
that it imagines,
what is
that the court can take into account how the 403 changes affect the calculus. So that blows a hole in their idea that that Congress never wanted these changes to have any effect on final sentences.
And you can take it into account because the statute says so, right? Is the government's view that you can take it into account because this statute requires the court to refer to 3553A, and 3553A says sentencing disparities have to be taken into account?
That's exactly right. The other point I would make, Justice Gorsuch, and it's baked into your question, is that this is an inference. It is an inference from congressional silence. And all of the government's arguments ultimately rest on trying to find implied limitations from congressional silence. The government wants to infer, and it's not just an implied limitation, it wants to infer a categorical bar against consideration of this fact,
does the lack of speech say we can, or does the lack of speech say we can't?
And it wants to infer not just a categorical bar on that factor, but a categorical bar on that factor ever entering into the equation, even though, in combination with other factors or alone, even though Congress didn't do that when it identified a specific factor, rehabilitation, as one that's off limits. That is a lot of meaning and content to read into congressional silence. There are at least 5 statutory rules of construction here that counsel against exactly that inferred limitation. The first is the most basic one, that this court does not lightly assume that Congress omitted from statutes text that it meant to apply. That's Justice Scalia's opinion in JAMA. The second one is the rule that where Congress puts a specific limitation in a particular provision, you don't infer another one.
But they're asking about
the third is the rule from Kimbrough. We're dealing with the sentencing statute. Congress has said, this court has said Congress knows how to direct sentencing practices in express terms and has shown that it has done so. The fourth is the Concepcion principle. You start with the premise that Congress meant district courts to have the broadest possible discretion unless the Constitution or Congress explicitly limits it. It hasn't done so here. And then finally, you add on top of that, because you have an express delegation to an agency or here to the commission, Justice Thomas, your opinion in Little Sisters of the Poor made clear that where there is that kind of clear and express delegation, you rewrite the statute, you don't apply it if you start inferring limitations on that discretion that Congress did not apply. I will just make one more point about the scope of the commission's discretion, because Justice Kavanaugh, I think you got that exactly right in the first argument today. This case is much simpler because Congress gave the commission the responsibility to describe what should be considered extraordinary and compelling factors. The commission has done that. So the question in this case is very simple and straightforward, and the question is just, did the commission's policy statement B6, is that a valid exercise of expressly delegated authority?
When you said middle ground earlier, you were really focusing, I think, on the 10-year point. Is that accurate?
It's not just the 10-year point. When the commission first took this issue, it was urged to adopt a provision that would have said whenever changes are inequitable in light of changes of the law, that would have allowed it. It didn't adopt that provision.
Do you think they could have adopted that?
I think that probably would have been within the scope of the commission's discretion. But I'd like to make 2 points about the government's parade of horribles here. The first is there there's nothing in the commission's history or its composition that would suggest it's going to adopt anything like the kinds of proposals that the government fears. In fact, the commission's history is that it has been quite cautious, not cavalier, about the use of this power. If it did adopt any of those outlandish proposals, the guidance has to go in front of Congress for 6 months before it goes into effect, and Congress could reject it during that time, as Congress has done with previous commission guidance. And then the second point is the fact that the commission could have gone farther, but chose not.
So I want to be clear here because we're going to be hearing a couple of arguments, so we have a second. This is an amicus filed by former federal judges. It said the court should grant certiorari for another independent reason, nullifying the Sentencing Commission's authority in these circumstances fundamentally undermines Congress's aim for the commission by depriving the commission of its ability to eliminate sentencing disparities between identically situated criminal defendants. Something to keep in mind. It's a brief for former federal judges.
For example, if the commission were to say that rehabilitation alone were an adequate factor.
What beyond that?
There were questions earlier about whether the commission could say, you district court may disagree as a matter of principle with mandatory minimums. And we would say that it would be a violation of the specific directive of Congress, that is a reasonable punishment for that offense.
Well, is there a provision that says specifically that the commission cannot do that?
There is a provision that it's general principle that the commission obviously can't violate.
It's an inference from the imposition of a mandatory minimum, right? That was what it would be based on.
No, that would be based on the fact that Congress said you may sentence someone to this offense. If the commission said, district court, you may take your own disagreement with Congress about that as a policy matter, not in the context of the specific case or the circumstances of the prisoner's overall situation, that would be in conflict with an act of Congress.
I'm not sure I understood that. What is the difference between the inference that one would draw from a provision that imposes a mandatory minimum, namely that Congress did not want that to be disregarded in any case, and the inference that one might draw from a provision that says this change in the law will apply retroactively to this limited class of cases but no other? What is the difference between those two inferences?
The difference is the latter does not take into account all of the circumstances that warrant relief in the prisoner's particular case. B6 is all about the individual circumstances, whether in context the sentence is unusually long, whether it creates a gross disparity, whether the circumstances warrant it. The one that you hypothesized is an across-the-board, non-contextual rule that Congress can never consider.
All right, thank you.
Then I don't understand your answer to Justice Kavanaugh. You said that if the commission said every prisoner is entitled to compassion.
Okay, let's talk about this real quick. That was Sotomayor, by the way. The Sentencing Commission adopted a provision, Section 1B1, 13B6, that permits district courts to consider a sentence reduction where, among other things, the defendant has served at least 10 years of an unusually long sentence and a non-retroactive change in law produces a gross disparity between that sentence and the one likely to be imposed at the time of motions. The Court of Appeals are divided on the question.
Itself an abuse of discretion. I'm very surprised at your answer to him, because it seems to me that the logic of your answer on the mandatory minimum is that if they do something so extreme as to ignore that Congress has not made this retroactive to all prisoners, Why isn't that equally an abuse of discretion?
Because the proposal that I was addressing, the inequitable in light of changes in the law, that incorporated individualized considerations. What I took the question to be asking about was an across-the-board, non-contextual rule that a district court may simply disagree with the policy of a mandatory minimum and treat that as an extraordinary and compelling reason. And that was Justice Alito's question. What I said in response to Justice Kavanaugh was that the commission could have adopted a rule that didn't have all of the limitations that B6 ultimately adopted, and simply said that.
I don't understand that they had to have some limitations, according to you.
Right.
They had to list some individual factors, correct?
That's correct. That's correct. And even that proposal would have been based on the particular circumstances of the prisoner's condition and circumstance.
So we're talking past each other. We're not talking about you arguing that they can say this always constitutes a reason for compassionate.
We believe that a rule
standing alone.
Standing alone, exactly. We believe standing alone that would be coming very close to trying to treat 403A as retroactive, and we concede that that is further than the commission could go.
Justice Kagan?
Mr. O'Neill, same question that I asked Mr. Frederick. If your position is right, does the inquiry into sentence disparities in these gun cases start to look a lot like the inquiry into sentencing disparity in the crack cocaine cases? And if it does, is that odd given the textual difference between Section 403 and Section 404?
The analysis is completely different between the crack cocaine cases and the kind that are covered in B6. The federal defender's brief does an excellent job of explaining how different these procedures are. With 404, which was an actually retroactive law, district courts set up standing orders. Defendants were waived through because there was no question at the eligibility. It was all about the 3553A factors. Here, every case is considered on its individual facts. The courts exhaustively look at the prisoner's individual circumstances, and the statistics bear out this difference. So during the time that, as Mr. Frederick said, I think there have been 150 grants in total under B6. During that time, under 404 and the crack cocaine cases, there were 4,000. And that is a demonstration of how different these regimes are.
Thanks.
Justice Gorsuch, Justice Kavanaugh,
Yeah.
Justice Jackson. Thank you, counsel.
Thanks very much.
Mr. Fagan?
Yeah.
Thank you, Mr. Chief Justice, and may it please the court.
This is the previous attorney we heard in the last
The core
case.
of the sentence reduction motions the petitioners are making in these cases is that they'd have received lower sentences if they were sentenced after the First Step Act's changes to Section 924C. But in enacting those very changes, Congress made a categorical judgment to, in the words of the principal opinion in Hewitt, leave Section 1924C offenders with final sentences stuck with their old sentences. That categorical judgment can't be leveraged into extraordinary and compelling reasons that warrant reduction in petitioners' lawful, indeed legally mandated sentences. This Section 3582C1A1 isn't a license for either individual judges or the Sentencing Commission to create what's effectively a new form of judicial parole, where someone who does not have extraordinary and compelling reasons warranting a sentence reduction can suddenly claim that they do in light of an expressly non-retroactive change in the law. Now, I think that's exactly what the Commission's done here. So to respond to the suggestion that this is a moderate middle ground solution, it is anything but a moderate middle ground solution, because as to 924C offenders, which were top of mind when this was adopted, it includes basically everybody. Take the 10-year limitation. The minimum sentence for a stacked 924C offender is going to be 30 years, 5 for the first mandatory minimum and 25 for the consecutive. That could be characterized, the difference between that and say a 10-year sentence under the new regime could easily be characterized as a gross disparity. And then we are down to, I think, basically just the individualized circumstances. And then we have judicial parole. If I may have one more second, if you listen to the reasons that Mr. Frederick gave for letting his client out, family circumstances and rehabilitation, that would be exactly the kind of reason that would have gotten you out on parole. I'm sorry, Justice Thomas, and thank you.
What limits would you put on the Commission's authority to describe what a compelling interest is or what an extraordinary circumstance is?
Well, I don't think that they can simply disagree with Congress or authorize individual judges to
can they do that? What I'm hearing is
but
that
according to the former argument, they're not disagreeing
alone,
with Congress. They're saying
disagree
you didn't say anything
Congress.
about
That's
this.
what I'm hearing from the other
And this
side.
is Thomas.
But if it's a part of a totality of the circumstances inquiry, then they can disagree with Congress.
I think the fundamental problem with that, Justice Thomas, is exactly what I just said, which is that it's a form of judicial parole. If you think back to what I said in the last case, essentially we are taking as a given that the other circumstances, the other reasons are not in themselves something that would warrant a sentence reduction. They're not extraordinary and compelling enough. What gets them over the line is the fact that Congress adopted a non-retroactive change in law that it explicitly decided not to apply to prisoners in their circumstances, and that is what gets them consideration of these other factors that wouldn't be enough on their own.
So what do you say to the argument that it's not necessarily a direct attack, a disagreement with Congress, but rather the effects of the provision, say, for example, non-retroactivity?
Well, I think this is a direct attack on what Congress did because Congress drew a categorical line, and as the principal opinion in Hewitt recognized, that was partly to prevent all the relitigation concerns. I think the fact that, as my opponents acknowledge, these are even more burdensome to litigate than Section 404 adjustments to sentences, which Congress expressly did make retroactive, is a strike against it. When Congress makes categorical judgments and it wants to allow for exceptions to individualized circumstances, it will enact something like the safety valve, which for mandatory minimums, which it again adjusted. That's in Section 402 of the First Step Act. And here you have what the Sentencing Commission in 2021 estimated was 2,412 offenders with stacked 924C sentences who'd be affected if this became retroactive. And as I was just suggesting earlier, this is essentially a full retroactivity provision in the sense that it opens the door to things that were not extraordinary and compelling reasons suddenly crossing that threshold.
So, Mr. Fagan, you said that a couple of times, and that I don't know that that's actually consistent with how this works in real life. In other words, you set up your argument both in the prior case and in this one to suggest that the court is marching in seriatim through these various criteria, and it starts with age, and it says, this is not extraordinary and compelling enough. Let me add illness. Oh, let me add, sentencing disparity. And that things that previously would not be enough to get them over the line suddenly become so when you add in this other factor. My understanding through conception and also experience is that that's not exactly how it works. The court is looking at the totality of the circumstances. It doesn't necessarily go through and determine whether each individual criteria itself is an extraordinary and compelling circumstance. So, for example, age would never be, that's not extraordinary. Everybody gets old. So it's not really doing an individualized tick off the box for each criteria, and therefore it becomes problematic.
And would never have been sentenced to that. They're going to consider the totality.
So if I reject that characterization of how it works, do you lose?
Well, Your Honor, first of all, let me just tell you that that's not exactly what I'm saying that they do. They don't just lie. I'm not suggesting
but
that anyone
you said many times that criteria that would not in themselves qualify as extraordinary or compelling circumstances become so by adding in this, and that's the problem.
So think of it this way, Justice Jackson. It's as though you are weighing something and it has to weigh enough. It has to be.
But I'm telling you, if I reject that characterization, you're starting with the empty scale and you're putting all the things on, not one at a time and seeing whether or not each thing gets you across the line.
Your Honor, you're not necessarily doing it one at a time, but I think even they would acknowledge that their claim is that they are not making the claim that if the question presented didn't matter, that is, if this were not a valid consideration, they would be eligible
They're
for
saying
relief.
you should not restrict the district court from doing a totality of the circumstances analysis that takes into account all of the circumstances. That the way you're setting this up, you're suggesting that certain circumstances should be left out because they're inappropriate. And in that case, the court should not have any ability to consider them. And what I guess I'm suggesting is that we all seem to agree that this is a totality of the circumstances. And so why can't the court take this sort of thing into account, especially in this case where Congress has made a policy determination that indicates that creates a sentencing disparity and indicates that this is a really unfair circumstance?
Well, I guess 2 points to that, Your Honor. It's not phrased as a totality of the circumstances as such. It's extraordinary and compelling reasons that warrant a sentence reduction. And so
that's
you have to consider
totality.
whether something that is being put on the table can contribute to that inquiry. I guess the second point, which builds on the first,
then ask yourself this. Just ask yourself this for a second.
You have a mix, and you don't have to
what one
tease it out
individual
into individualized reasons
would you, as a
necessarily,
normal
but if you have a
person,
mix
see as extraordinary
that is
and compelling?
not going to be sufficient.
Just
the
one.
other reasons
You can only
that
pick
Mr.
one of
Frederick mentioned this morning, and they're not going to be sufficient on their own. I think their claim in this case, the only way they can succeed in this case is if they are allowed to add this additional factor to the mix. Now, the upshot of adding that additional factor is they're adding something that is manifestly not extraordinary and not compelling because it is the normal operation, and here the express operation, of non-retroactivity law.
Sorry, go ahead and finish.
And it also, again, I hate to keep repeating myself, but I think it's a point worth really driving home yet again. It's effectively, if you think about it on the flip side of the coin, creating judicial parole by unlocking the door to things that would not be extraordinary and compelling if that consideration were not on the table, and all of a sudden they can become a reason for release. Thank you for your patience.
I just wanted to ask you about your Loper-Bright point and the degree of discretion that the Sentencing Commission has here. I'm going to state it, and then you tell me if I'm understanding your point correctly. You don't dispute, Justice Kavanaugh pointed out that the terms extraordinary and compelling are capacious terms. And so the Sentencing Commission does have some discretion within words like that to enact policy statements. Right. Correct. Okay. I'm getting to the point I think that you want me to. Your point about Loper-Bright is that discretion has to happen between certain goalposts, and the fact that the First Step Act has imposed a rule of non-retroactivity means that the commission has exceeded the limits on its authority. So it's not that it doesn't have a lot of discretion, but here it's bumped beyond that.
That's exactly right, Justice Barrett. And I think one problem with their position, and I think it's been well illustrated in the other arguments in this case this morning, is there's really no limiting principle to what they're saying the commission could do. They are, I admit I'm a little confused as to what their answer is to the hypothetical where the commission just decides to allow courts to disagree with mandatory minimums. But I think the reason they're not giving you a clear answer that the commission couldn't do that is because it logically torpedoes their argument. Because in their view, the commission can say anything it wants as long as it hasn't expressly precluded sentence reductions. But of course, a mandatory minimum like the one in 924C just says the defendant, if you look at the language there, that it just says the defendant shall be sentenced to a term of no less than 5 years.
So define the goalposts for me.
Yeah,
you're saying
that's what
they've
I'm trying to
gone
get
past some goalposts, but Congress has not said anywhere, you commission can't look at non-retroactive changes in law.
This is a great
It hasn't
question.
said you can't look at changes in mandatory minimum. It hasn't said, the only thing you can't look at alone, it said, is rehabilitation. That's the only limitation Congress has said.
That's true.
Well, it has
It's
said,
accurate.
Your Honor, under 994A that the Commission's policy statements have to be consistent with law. As for rehabilitation,
Well, there is no law that says that.
Exactly.
There's no law that limits what they can consider.
well, Your Honor, I
As
think
a-
even, I'm sorry,
And 3553A, thank you, I'm tongue-tied on that one, does permit courts to look at disparity with co-defendants or with others. So I don't know where you're defining that the goalpost is defined
Thank
by
you.
something that's not specified in law.
Thank you.
So let me tease that out a little bit. I think they're not trying just to look at, there are a few points. Number one is the colloquy I was having with Justice Kavanaugh in the first case about why the 3553A factors aren't the relevant consideration at this part of the inquiry. But even beyond that, they're not just looking at disparities alone. They're looking at disparities with offenders who were sentenced under a non-retroactive law that applied to them, but didn't apply to these offenders. And I think even even my friends on the other side would have to agree that you can draw some implicit lessons from Congress's enactments. To get to Justice Gorsuch's questions, that's exactly why the Commission would claim that it has exempted its own non-retroactive amendments from its policy statement. It's because it believes that if it didn't do that, it would be overriding the limitations in 3582C2. And if it can't override 3582C2, I don't understand why it can override Section 403B of the First Step Act. Essentially, what they're saying is that because none of these statutes expressly speak to sentence reductions, I guess 3582C2 does to some degree, but it doesn't expressly preclude the use of 3582C1A1 when there are other circumstances involved. Because they don't expressly speak to sentence reductions, they are automatically possibly on the table. And if that's true, then there are substantial separation of powers concerns because then they essentially have the pen on sentencing law. Now, if I could address rehabilitation for a second, Justice Sotomayor, I think there are a couple of points. One is rehabilitation is something that I think could otherwise have been considered an extraordinary and compelling reason. I think there are examples of many prisoners who would claim that they have extraordinary and compelling stories of rehabilitation. One thing that they're able to do under their position is just to take that rehabilitation, combine it with a non-retroactive change in law, something we know Congress didn't want to apply to these kinds of offenders.
So do you think that someone who has rehabilitated, been in jail for 40 years, let's say, and is now 90 years old, and they have spent most of their life in prison, could not have a claim for compassionate release if they come in and said, I'm 90 years old, I'm going to die soon, because rarely do you last very long after 90. The chances are very slim. And now there's been a change in law. I can't qualify under your reading of this.
So, Your Honor, in the absence of B6, even the Commission wouldn't allow release under those circumstances because it's not age as such. It's limited, I think it's B2 is limited to age-related.
So your answer is that wouldn't be enough?
I think it might be within the...
And there, I didn't add that there was a change in law, all right? Because that's what's at issue here.
So, Your Honor, I think that those may not be extraordinary and compelling on their own. If they were extraordinary and compelling on their own, we wouldn't have, this question wouldn't ever come up. The other problem with 994T, I think that's a real problem for them, is they don't if they want to follow the expressio unius principle from the consideration of you can't consider just rehabilitation alone to its logical conclusion, then I don't see how they're able to maintain their position. What 994T says about rehabilitation is that it's a consideration that can be considered in conjunction with other factors, but not on its own. But that seems to be exactly how they're treating non-retroactive changes in law as well. So if they think 994T is something that says only rehabilitation can be treated in a particular way, they're violating their own principle. I think 994T is just about limiting consideration of that one principle. If they instead think that non-retroactive changes in law can on their own be reasons why someone could get a sentence reduction, then I think there are even further problems with their position. But under their position, the Sentencing Commission could, in theory, come out with a rule that allows district courts simply to disagree with mandatory minimums. And then as we specify in our brief, the district court says at sentencing, well, you don't qualify for the safety valve. Unfortunately, even though I'd rather not, I'm forced to sentence you to this mandatory minimum, but I'd be very open to a compassionate release motion. The prisoner files one the next day, he waits 30 days, and the district court, because the BOP is not going to endorse it, and then 30 days later, the district court's able to...
Let me real quick, I'm going to go over this because this guy's highly whiny and his voice pisses me off. So before the First Step Act, on your first count, it was a 924C convictions, right? Like, you get a mandatory minimum of 5 years for the first count. The second count, before the First Step Act, mandatory minimum of 5 plus 25 years, so 30 years. After the First Step Act, the mandatory minimum of 5 plus 5 years, so 10 years. So this is a 20-year difference in sentencing that they're sitting here saying it's going to create this huge loophole, which obviously it hasn't. The circuits are split 6-4 on this issue. That's crazy.
That Congress did not want anybody who was already serving these sentences to benefit from this sentence reduction. But I think there's also the possibility that instead of that inference being drawn from the retroactivity determination, there's the inference that Congress did not want to impose all of the administrative burdens that would apply or that would arise if there was categorical application of this to everyone without, the way in which retroactivity works. If we believe that that's what Congress was saying, that's what Congress was saying when it said no retroactivity, there isn't a conflict with a circumstance in which you look at 3553A and you look at 3582, the compassionate release, and take into account something like sentencing disparity.
Well, Your Honor, I think it's difficult to look at 403B, particularly in context where Congress did enact other retroactivity mechanisms, and plainly did so because in the entire interregnum period between the Fair Sentencing Act and the enactment of Section 404, which made the Fair Sentencing Act of 2010's changes for crack cocaine offenders retroactive. And during that entire 8-year period, no one ever thought that Section 3582C1A1
why would somebody with
similar
circumstances
some subset of those
before and
offenders.
after
I think it's
have
a little difficult to look at
difference
403B in that context and see it as anything other than as a policy judgment to leave offenders who had final sentences stuck with their old sentences.
What do we do with the fact that Congress did not speak to its directive in the compassionate release scenario, that you look as a judge to 3553A, which allows for consideration of sentencing disparities? It seems to me that if you're right, Congress would have needed to amend the compassionate release statute, either within the statute itself or taking out 3553A or addressing it like it did in 994T to take sentencing reductions out of it.
I don't think so, Your Honor. I think that's imposing kind of a clear statement rule on Congress to exclude particular enactments of law from the operation of 3582C1A1. It certainly didn't do so in 924C itself in saying a defendant shall be sentenced to a particular offense. And to your earlier point about administrative burdens, I think what Congress would have been creating if it allowed for this kind of judicial parole system is an even greater administrative burden on the courts, because what it's telling, what it's reenacting is exactly what we had pre-Sentencing Reform Act, where there's kind of a forced rehabilitation scheme. We talked about this a little bit in our brief in RICO, the case the court heard last Monday, where prisoners think that they need to rehabilitate, and that's how they're going to get out. And so they work to rehabilitate. And 5 years from now, we'll see each of these 2,412 affected 924C offenders, to the extent they haven't already been let out, claim rehabilitation. And if that fails, they'll file another one a couple of years after that. And I don't think that's the scheme that Congress was creating, which is even more burdensome than some of the streamlined schemes that were developed under Section 404.
I want to take it back to something that was presented at the very beginning of this. There are thousands and thousands of people that apply for this. 56 have been granted, I think they said within the past year or so. Thousands versus 56. Like, they're creating this, like, it's a problem that's not existing as we can see it.
Or essentially exactly what Congress then decided to do in 403B, and was making up for that for the set of prisoners who were still in prison for those offenses. I think actually the fact that Congress was deliberately doing that is truing up offenders where it had enacted a 403B-like scheme, and at the same time enacting 403B, really does point up that contextually Congress could not have meant to be allowing the kind of thing that petitioners say they're allowing here. Nor would it just be 403B, because Section 401 of the First Step Act made some further changes to the drug sentencing provisions of 21 U.S.C. 841, changing the nature of the predicates. And for that, there is a 401B that looks exactly like 403B. And there's another, the commission estimated in 2021, 3,742 offenders who'd be affected by that. So to the extent they're still in prison, it would be opening the door to sentence reduction motions by them. There's another level of the problem here, which is that the Commission's Rule B6 also purports to authorize reliance on other non-retroactive changes in law. So we will get things like, and are getting things like, claims under Booker, United States against Booker, which is non-retroactive, about the changes to the guidelines, the advisory guidelines, and all sorts of other claims about non-retroactive changes in law. So you will get some kinds of things that would have been a problem, that would exhibit the sorts of problems I was mentioning in the last case, where something has to be retroactive in order to qualify as a valid Section 2255 claim. I mean, it's an overused...
Can I just ask you one more thing about the commission? Yeah. How is it that the commission is way out of line in a situation in which the courts were deeply split on this issue to begin with before the commission even entered?
Well, Your Honor, I don't think the mere fact that the courts were split reflected that the commission could resolve that reasonable policy disagreement, because as we...
So you're saying the commission had to choose, it had to pick.
Well,
either
as we
you can never use it or you can always use it, because that was the split.
As we expressly told the courts, like once this and is the Third Circuit recognized in this case, once one of the courts, the 6 courts that went in our favor as opposed to the 4 that didn't, I mean, once they agree with us that this is not a valid consideration under the statute, the commission doesn't have the authority to adopt under the statute. And this is also what the 3 dissenting commissioners said. The commission doesn't have the authority to adopt under the statute, something that the statute doesn't in the first place allow.
That just means you disagree with the commission's statutory reading. I guess I'm just trying to understand why it's unreasonable, given that some courts agreed or thought that it was okay under the statute.
That fucking part.
The commission just, it seems to me the commission agreed with the courts that didn't agree with you, said it was okay under the statute, but only under these limited circumstances. Why is that just completely an abuse of the commission's authority?
I mean, to put brass tacks to it, Your Honor, the 4 courts that thought this was permissible under the statute are wrong. And it's not just it's not resolving some sort of, you know, you could do it one way, you could do it another way kind of disagreement between the courts of appeals. if you can't do it under the statute, which is what the majority of courts had said, then the commission can't do it either, and they can't do it in a purportedly limited way that, as I've mentioned earlier, is not particularly limited. But as I was about to say, I mean, I think it's an overused kind of homily that Congress doesn't hide elephants in mouse holes.
If the majority of circuit courts got to proceed over the
hidden in this mouse
others,
hole, for Congress to have done with Section 3582C1A1 reductions, and I don't think there's any evidence in the history, any evidence in the context that that's what Congress was directing these things at. I think this applies to both the cases this morning, both Section 2255 claims and non-retroactive changes in law. There are often cases in which Congress decides to ameliorate sentences going forward. The court has described those as perfectly ordinary decisions by Congress. It's also the ordinary business of the courts to reinterpret statutes, which can also be non-retroactive, particularly where they're just dealing with procedural matters. And I don't think Congress was opening the door up for those kinds of claims either. Even if a lot of these claims are going to be rejected, they are quite burdensome on courts. That's true in the 2255 context, where you've essentially got new habeas motions or post-conviction motions. And it's going to be equally true in this case, where the court has to go through the individualized circumstances of each defendant and try to combine all the apples and oranges to figure out whether this particular prisoner is deserving of relief.
I guess what strikes me, Mr. Fagan, is that there is neither an elephant nor a mouse hole here.
Kagan.
Not a mouse hole, because Congress is perfectly well aware of sentencing modification proceedings and knows that this is an important part of the criminal process. And then not an elephant in the following way. I mean, what you're saying is that when Congress set up a rule that says this statute should apply prospectively, not retroactively, Congress must have meant with respect to everybody in all circumstances. And that seems, I think I'm going to make you repeat your argument about why that's true.
No, because you won't say anything. So many words to not say a goddamn thing.
The Sentencing Commission could not say, of course, if you come in the sentencing proceeding, we'll give you relief no matter what. All you have to do is point to a sentencing disparity. Then I might say, okay, now you have an elephant problem. But that's not what the Sentencing Commission did. The Sentencing Commission set particular criteria, and then on top of that, said only given all the surrounding circumstances of your case. So what the Sentencing Commission did was to say, we're respecting the rule that Congress has set up, but the rule that Congress set up is a categorical one that doesn't ask us to say within an individual case that the sentencing disparity can have no weight at all.
Well, let me address the mouse hole and the elephant point separately. As to the mouse hole point, I think we did have a mouse hole here because neither they, nor any of their amici, nor any of the parties or amici in the previous case have ever pointed to a single instance of Section 3582C1A1 ever being used for these kinds of legal changes that they're pointing to in these set of cases. So I don't think Congress had any reason to anticipate that this was an option on the table. I realize I have. I apologize.
Why don't you finish and then we won't.
I won't ask any more questions.
And we do have stoppage time. So as to the elephant, Your Honor, I do think that this would be authorizing quite a lot, because I think there's been a lot of focus on what's going to get granted and what isn't. I think there are a lot of motions that are going to get granted. It's not a huge and significant difference, but we are seeing higher percentages of grants in the circuits that do allow consideration of non-retroactive changes in law. I think we have every reason to believe that that could increase in the future as prisoners decide to build up some kind of record that might suggest rehabilitation and then force the courts to evaluate whether they have done enough. There is absolutely no time limit or numerical limit on the number of these motions that we will see.
They didn't say you couldn't consider rehabilitation. They just said it couldn't be the only consideration.
You don't get a chance. Justice Gorsuch. Justice Jackson?
Thank you.
counsel. Rebuttal, Mr. Frederick.
Okay, got a couple minutes left.
I'd like to start with Justice Barrett's question. To accept the idea that Section 403B applies in the way the government advocates here would be to accept the proposition of implied repeal of provisions of the 1984 Act. Nothing in the 2018 Congress suggested that Congress intended to limit the scope of considerations that the Sentencing Commission would authorize. I would accept, though, that under your hypothetical as you posed it, if the Sentencing Commission came and said it shall apply to pending cases, contrary to what Congress said specifically in the 403 provision, that would be ultra vires and outside what the Commission did. But I would urge you to look at the words in 994T, which give the Sentencing Commission very broad authority to come up with factors, a list of criteria, and to explain the circumstances in which extraordinary and compelling would apply. Justice Gorsuch, to your questions, I would suggest that the standard for dealing with an implied repeal are very strict. And so to accept the government's notion here, you would have to accept the idea that words that had nothing to do with compassionate release nonetheless were intended to impose limits, and that judges would be authorized to create limits. And yet that goes against a number of this court's canons. One is the idea we don't have an implied repeal unless there's a strict standard that is met. We don't ask for judge-made rules that interfere with congressional statutes that give broad authority. And the third is the idea that we would accept the principle that a statute that speaks directly to a question is somehow going to be negated in some fashion sub silentio by a later enactment. I would urge you also to consider that sentencing length is always part of these compassionate release motions. That doesn't mean that it is an automatic application of
That part.
the revocation
It's a
of the statute
totality
that
of
occurred in the
circumstances.
2018
Totality.
Act. It could very well be that a judge says you're automatically would have gotten 18 years lower, but because of your prison conduct or because of other factors, I deem your reduction only to be 5 years. This court doesn't need to decide what the extraordinary and compelling circumstances are. It should be for district courts to decide that. All we're asking you to do is to say that judges are not authorized to preclude the consideration of factors that district courts can take into account. This is not a mechanical exercise. It looks at the individual circumstances of every inmate to determine whether, based on the totality of the circumstances, that inmate is entitled to a reduction. Thank you.
Thank you, counsel. The case is submitted.
Okay, this has been a long one today, and I don't have very many viewers left, so I'm going to go ahead and get off, but you can DM me if you have any questions. And I will see y'all all December 1st. Talk to you soon, guys. Bye.